I'm not used to using chat in this. I'm not probably used to using chat at all. So it's a learning experience for me. Okay, if we have all the judges here, I ask the judges to then disappear from the screen, and we'll get the teams, get working with the teams. Okay, let me confirm it from a team representative. Are all the participants for the team present and ready to go?
Yes, Your Honor, the prosecution is ready to proceed when necessary.
Is the defense ready?
The defense has just one more thing we need to figure out before we can start. So we're going to have just 1 minute. That'd be fantastic.
Okay, you get the minute. Just signal me as soon as you've got your technical problem solved.
Yes, Your Honor. Your Honor, the defense is prepared to proceed as well.
Okay, let's start. Well, let me start with some observations. Let me begin by welcoming both teams to the fourth round of the competition. And the host has asked us to remind you that, yes, this is a competition, but let's also have some fun. Is there a recording being made of this trial? Will someone speak for confirm whether there is or is not a recording being made?
Yes, Your Honor, there is a recording being made.
Have both sides consented to the recording?
Yes, Your Honor.
Okay, fine. A couple other reminders. The no communication reminder for all of you. There's no communication allowed between competing team members and anyone else in the courtroom until the trial is concluded. Another reminder, no authorized persons are allowed in the courtroom. So unless you have some connection to the teams here or with the host, we ask you to get out of the courtroom. And third reminder, remind you that there should be no identifying factors related to the team. Don't tell us your name. Don't tell us where you're from. Don't tell us anything that would indicate your identity other than the number that you've been assigned. Timekeepers, I just want to confirm your presence. Would you just signal us that you're present? Either come on screen or speak.
The prosecution.
I hear. Okay, the prosecution's timekeeper is ready. Defense timekeeper?
Timekeeper is also ready.
Okay, great. And I've always liked to thank the timekeepers. They do a job that's not necessarily, is certainly not um, what I would describe, not something I would want to do if I had the choice, but I appreciate that they do. It makes mock trial possible. A reminder to observers, please make sure that all electronic devices, and that reminds to myself, are turned off or at least put in silent mode. Let me finish that task for myself. And please, observers, keep your web cameras off for the duration of the trial. Reminder of both teams that witnesses are deemed to have been sworn before trial, so there will be no swearing ceremony done before a witness takes the stand. With all those things done, let's get to some of the business. Let's get team introductions. May I hear from the plaintiff prosecution team, which is number MRT.
Good morning, Your Honor. I represent the MRT team of the prosecution. My name is Nathan Cho, and I use he, him pronouns. I will be delivering the direct examination of Cassidy Sutton, as well as the cross-examination of Harper Karpus. I'll also be delivering the closing argument for the plaintiff side.
Good morning, Your Honor. My name is Samantha Harkey. I use she, her pronouns. I will be delivering our team's opening statement, direct questioning Charlie Floyd, as well as cross-questioning Jesse Hurst.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Dane Lester. I use he, him pronouns, and today I'll be direct questioning Agent Kelly James, as well as cross-questioning the defendant, Parker Barrow.
Good morning. My name is Alexandra Guerra. I go by she, her pronouns, and I'll be playing Charlie Floyd.
Good morning, Your Honor. My name is Aveline LaRoque. I use they, them pronouns, and today I'll be playing Kelly James and serving as the timekeeper for my team.
Okay. Thank you. And
morning.
finally?
Good morning. My name is Aurelie Olivares. I use she, her pronouns, and I will be playing Cassidy Sutton.
Okay, thank you. Now let's get the defense team introduce itself, the JBB team.
Yes, Your Honor. My name is Dallin Christensen, and I, along with my co-counsel, will be representing Parker Barrow in today's case. My co-counsel will now introduce themselves.
My name is Matthew Hatch.
I think Mr. Christensen needs to turn his mic on. I'm not hearing Mr. Christensen.
Good evening, Your Honors.
Okay.
My name is Hunter Urisk, and I'll be doing the direct examination of Harper Karpus, as well as the cross-examination of Agent James.
And your witnesses.
Our witnesses will now introduce themselves in their order of appearance, to be followed by our timekeeper, who will also introduce herself.
My name is Peter Hawkins, and I will be Harper Karpus.
We had a little audio lag there. Could we have that repeated? I'm not hearing any of the witnesses introducing themselves at this point.
Your Honor, my name is Mia Sharp, and I am Parker Barrow.
Okay.
Good morning, Your Honor. My name is Simon Kisby, and I am Jesse Hurst.
And we have a third team member as a witness.
My name is Peter Hyde, and I will be trying Parker Carpus.
Okay. I'm still having trouble and I didn't see you. So let's see if we can get your video as well as your audio. At the moment, at least according to the screen, Mr. Hyde, your audio is turned off. So you need to unmute yourself.
Your Honor, I will be using this computer for the purpose of the trial. And my name is Peter Hyde, and I will be Harper Carpus.
Excuse, are you playing Parker Barrow? Or you said Mr. Parker Carpus?
Harper Carpus, Your Honor. We will be using the same computer. We will switch the names when we come up to our examination.
Okay, fine. So
I'm so sorry, Your Honor.
Yes, you're the timekeeper.
Yes, my name is Emma Ollenslager, and I'm the timekeeper for the defense team.
Okay, thank you very much. Okay, at this point then, let's start with any pretrial requests or matters that we need to discuss, starting with the plaintiff team.
Yes, Your Honor. May I proceed?
You may.
Your Honor, may the prosecution assume that all exhibits have been shared with all members of the court, including opposing counsel and all members of the jury?
I believe that is the case. From the defense side, is that your understanding as well?
Yes, Your Honor.
Okay, then we'll proceed with that assumption until something indicates that the assumption is wrong. Mr. Lester, do you have anything in addition?
Yes, Your Honor. According to Mock Trial Rule 2.8 of competition, teams may substitute team members for different roles in order of an emergency. May the prosecution reserve this right in this competition?
I don't know that you have to reserve the right. I appreciate being made aware of it. Just tell me when it happens and make sure judges know the proper names that are being substituted at any time. Okay.
Of course, Your Honor. And may we also suggest that in the case of technical difficulties, team members may turn off their cameras to increase bandwidth and connection?
I'm not sure I understood. They can turn off their camera?
Yes, that helps increase the connection during the trial.
So we would not see them, but we would be able to hear them?
Yes, this is just in case of a scenario in which they are lacking.
Okay. We'll do that. I'd prefer to see them, but if we can't, because of technical difficulties, we'll hear them. Thank you. Anything else?
No, Your Honor, that is all at this time.
Defense, any additional pretrial requests?
Yes, Your Honor. We'd like to clarify a particular process, that is the sharing of exhibits with the court. Because of the online format, when we display an exhibit to any member of the court, that means displaying the exhibit to every member of the court. And as such, it changes the procedure that should be followed if we were in a physical courtroom. So the question I have is, would you prefer us to ask to display the exhibit to the witness and then again ask when we would like to publish it to the jury? Or would you just like us to ask once, and once it's up, continue the process of admission, and once it's admitted, if it's still up, continue with it up and work with it that way? Which would you prefer, Your Honor?
At least as to the first, when you're showing it to a witness, you may bring it up, and though everyone will see it, including hypothetical jurors, it will be seen. We'll just pretend that all those hypothetical jurors disappear from the online courtroom and until the exhibit is admitted into evidence. If at the second stage, after it's been admitted into evidence, I leave it to you to decide how much you want to display it. It's in evidence. You decide how much you want to publicize it or keep it up for your purposes.
Yes, Your Honor. Your Honor, at this time, seeing that both parties have stipulated that Exhibits 1 and 2 are admissible without further foundation, the defense would like to admit those at this time.
Okay, any objection, counsel?
As it is stipulated, no objections, Your Honor.
Okay, so Exhibits 1 and 2 are admitted into evidence.
Your Honor, the defense has no further pretrial matters.
Okay, then we should be ready to proceed with opening statements. So let's get the opening statement started. We'll hear first from Ms. Hatch, or
Harkey.
pardon me, it's Ms. Harkey for the prosecution. Ms. Harkey, you may proceed.
Thank you. This is a case about a silent theft. Not every bank robber waves a gun, demanding money. Some robbers stand behind the teller desk, ready to hand cash to their co-conspirators. We will show that that is what Parker Barrow did. On October 31st of 2019, Parker Barrow, a teller, was the lone employee at Third National Bank. A bank customer, Mr. Foley, entered to make his regular Tuesday cash deposit. Two masked women, Lori Busmail and Charlie Floyd, followed. Miss Floyd held a gun. Upon request, Parker Barrow calmly handed Miss Busmail a bag of cash, and the police arrived. We will show that Parker Barrow was a conspirator to this bank robbery. We will be calling 3 witnesses today. They will show that Parker Barrow committed conspiracy to rob a bank, bank robbery, and armed robbery. Firstly, we will call Kelly James, an FBI agent who investigated the conspiracy and robbery, will tell you how they concluded that Parker Barrow conspired to rob the Third National Bank with Charlie Floyd, Lori Busmail, and a 4th individual named Jane Doe. Agent James will explain that they entered the Third National Bank after the robbery, saw Parker Barrow looking nervous, and saw the sole security camera facing the bank ceiling. Agent James collected fingerprints off the camera, and the print matched those of Parker Barrow's left index finger. Agent James will also tell you about how they identified the ladder likely used to adjust the camera, and also found Miss Barrow's right thumbprint. Secondly, we will call Charlie Floyd. Charlie Floyd made the mistake of participating in the bank robbery. She will tell you about how the conspiracy unfolded and what happened on the day in question. The conspiracy began when Jane Doe recruited 3 co-conspirators to rob a bank. Miss Doe bought 4 disposable flip phones and handed 1 to each of the co-conspirators. Miss Floyd went to the bank on the week before the robbery, and she saw Parker Barrow with her flip phone. Miss Floyd will testify that Jane Doe said Parker Barrow was the inside woman. On October 31st, Miss Floyd brought a gun to the bank. She threatened Mr. Foley while Parker Barrow calmly handed a bag of cash to Miss Busmail. And lastly, we will call Cassidy Sutton. Cassidy Sutton is the bank manager at Third National Bank. She will tell you about how Miss Barrow's parents had expensive medical issues, so she needed money. Miss Sutton saw Parker Barrow eating lunch with Jane Doe. Miss Barrow was the last to leave the bank the night before the robbery. Miss Sutton will explain that after she left, the bank security camera was moved, and Parker Barrow was the only person who could have been in that bank. Miss Barrow suggested that our client take October 31st off. Then, on October 31st, the silent alarm located at her feet was never triggered. We will show that Parker Barrow is guilty of conspiracy to commit bank robbery, and armed robbery. Conspiracy, as explained in a case called U.S. v. Bauman, requires that only a person agrees to commit a crime. We will prove beyond a reasonable doubt that Parker Barrow agreed to participate in the robbery on October 31st. A person has committed bank robbery as explained in a case called U.S. v. Shaw. when she conspires to commit bank robbery and the robbery is reasonably foreseeable from the conspiracy. We will prove, again beyond a reasonable doubt, that Parker Barrow could reasonably expect the bank robbery to happen. If one co-conspirator possesses a gun, all of the co-conspirators are guilty of armed bank robbery, as explained in a case called US v. Stromiello. We will prove yet again, beyond a reasonable doubt, that Charlie Floyd possessed a gun during the robbery on October 31st. This is a case about silent theft. At the end of this trial, we will ask you to find Parker Barrow guilty of conspiracy to commit bank robbery, and armed robbery. Thank you.
Thank you, Ms. Harkey. May we hear the defense's opening statement? Mr. Hatch.
May it please the court, something is missing. Kelly James and the rest of the Midlands police officers arrive at the Third National Bank in Midlands. They start to spread out, searching for any clues as to who may have aided in this bank robbery. A case quickly begins to form. A case built on the testimony of criminals. A case that followed questions that already had answers. A case where the evidence is missing. Good morning, Your Honors, opposing counsel, and members of the jury. My name is Matthew Hatch, and I, along with my co-counsel, represent the defendant in today's case, Ms. Parker Barrow. Today, the prosecution bears the burden of proof to prove beyond a reasonable doubt the three counts against my client. The first one being bank robbery, the second armed bank robbery, and the third conspiracy. They bear the burden to prove it beyond a reasonable doubt. Members of the jury, that means that at the end of today's trial, if there's even a sliver of doubt in your mind, if there are still questions that don't have answers, if there are pieces to the puzzle that are still missing, you cannot find my client guilty. Today, the prosecution won't be able to meet their burden of proof. Why? Because something is missing. The story that the prosecution will try to tell you starts with my client, Ms. Parker Barrow. They'll tell you that she had a motive. Why? Because her father had expensive medical bills that she had to pay for. Jesse Hurst, the defendant's father, will testify to you today what the prosecution will not. He'll tell you that he and Ms. Barrow were able to pay every single medical bill and had no problems whatsoever financially. A motive is missing. The prosecution will tell you that Ms. Barrow had a flip phone similar to the ones used by the rest of the bank robbers. What they won't tell you is that the flip phone that Ms. Barrow had was different than the other bank robbers, and that she received this flip phone right when she got a new job, and that is what she used it for. They'll tell you that all the evidence points to my client, Ms. Barrow. What the prosecution will not tell you is that the FBI searched Ms. Barrow's house. They searched her computer, her car, her phone, and any other documents that they could find, and they found no evidence whatsoever that could link my client with the bank robbery. The evidence is missing. Finally, the prosecution will tell you that there's only one person who could have been the inside source for the bank robbery. Only one person, and that is my client, Ms. Barrow. What the prosecution will not tell you is that Mr. Harper Karpus, an expert in criminology who deals specifically in bank robberies, found that there was only a 50% chance that there even was an inside person in the bank robbery. And he'll tell you again that there was a 50% chance that that person was Ms. Barrow. Members of the jury, that means there's only a 25% chance, mathematically speaking, that my client was even involved in the case. And what about that other suspect? That other suspect is Cassidy Sutton, one of the prosecution's witnesses today against my client. They'll try to tell you to ignore this fact. They'll tell you that Miss Sutton was never involved. However, we as the defense will show that there was the possibility that she was. Time and time again, the prosecution's case will be full of holes, unasked questions, unexplained pieces of evidence. And you, the members of the jury, will see that something is missing. We ask you to find my client, Ms. Parker Barrow, not guilty at the end of today's case. Thank you.
Thank you, Mr. Hatch. May we now proceed to the prosecution's witnesses? Will the prosecution call its first witness?
Yes, Your Honor. The prosecution calls Kelly James to the stand. May I proceed?
Just a second, please. You may proceed.
Thank you, Your Honor. Can you please introduce yourself for the court?
My name is Kelly James, and I am a special agent with the FBI.
And what are your qualifications for being a special agent?
Well, I have investigated 12 bank robberies during my time with the FBI, 8 as a lead investigator. Most of my cases focus on white-collar and organized crime, though I regularly assist state officials with investigating federal crimes, namely bank robberies.
And what is your educational background?
I graduated from the University of Arizona with a bachelor's degree in economics and then worked for 4 years as an accountant. And of course, I graduated from the FBI Academy in 2012.
And what did you learn at the FBI Academy?
The curriculum focused on comprehensive academic, physical, and operational training, and I received additional training in forensics, evidence preservation, criminology, and fingerprint analysis.
Mm-hmm. And how did you get involved in the case at bar?
Well, I was called in to work with my team on the robbery of the Third National Bank of Midlands.
Thank you, Agent James. Now, you mentioned being called in to work today. Can you describe this call?
Certainly. At 11:27 a.m. on October 31st, 2019, the Midland City branch of the FBI received a phone call from the local police. They were calling to report an attempted armed robbery at the Third National Bank of Midlands.
And what did you do after you received this call?
Special Agent Maria Fonseca and I headed to the scene of the crime since the FBI has jurisdiction over attempted robberies of federal banks. Once we got there, we found that the local police had already cordoned off the perimeter of the scene. We also found a small group of civilians there, including one individual who kept shouting, "This is my bank, I'm the manager."
And what did you do next?
Agent Fonseca and I entered the bank. There, we found 5 people, 3 police officers and 2 civilians.
And who were these civilians?
We later identified these civilians as Parker Barrow, the sole teller on duty at the time of the crime, and Jackie Foley, a customer who witnessed the robbery.
And what happened after you entered the building?
One of the police officers took Foley and Barrow to the police station. After they left, the 2 remaining officers notified me and Agent Fonseca that 2 of the suspects, Charlie Floyd and Laurie Boozmail, were already in custody, with a 3rd suspect, the getaway driver, on the run.
Now, the prosecution asks that the court take judicial notice that this getaway driver be referred to as Jane Doe for the purposes of convenience throughout the trial.
Does the defense have any objection?
Your Honors, judicial notice is for facts. This is not a fact, though we are okay with this suspect being referred to as Jane Doe.
Okay, I agree that this is not a matter for judicial notice, but if the teams agree for purposes of convenience, yes, we can proceed on that basis.
Thank you, Your Honor. And Agent James, did you see anything unusual when you entered the bank?
Yes, I did. When I walked into the bank, I immediately noticed that the security camera in the lobby was pointed at the ceiling.
Did you investigate the camera?
Yes. My team and I discovered a 4-foot tall ladder in the bank's utility closet. We moved this to the location of the camera and determined that no one had tampered with the camera other than changing its position. We also discovered that the ladder was needed to access the camera and lifted a fingerprint from the ladder and 2 fingerprints from the camera. We tested all of them.
And have you received the results for these fingerprint analyses yet?
Yes. The fingerprint on the top rung of the ladder was an 18-point match to Parker Barrow's right thumb. The FBI considers it a match if 12 or more distinct points of comparison correspond. We were unable to identify one of the prints on the camera, but the other print, the one on the right side of the camera, was a 12-point match to Parker Barrow's left index finger.
Thank you. And did you complete any follow-up investigation after your time at the bank?
Yes, I did. I spoke to Jackie Foley over the phone, which yielded hardly any concerns, and I also spoke to Parker Barrow over the phone, which did raise my suspicions.
And what suspicions did you have?
Well, when I asked Parker Barrow about why the security camera in the bank was pointed at the ceiling, she paused for a noticeable time before answering. She also gave me information about her efforts to stop the robbers and her involvement with the bank that deviated from my findings.
Agent James, I understand that you have reviewed the security footage from the bank.
Yes, I have as part of my investigation.
Your Honor, permission to display for opposing counsel and the witness what has previously been identified and put into evidence as Exhibit 1.
Any objection, counsel?
No, Your Honor.
Okay. You may proceed to display Exhibit 1.
Thank you, Your Honor. Co-counsel, thank you. And are you familiar with this?
Yes, this is a fair and accurate depiction of the floor plan of the Third National Bank of Midlands.
And since you mentioned that you saw the security footage, can you describe the security footage referencing the locations on the bank as necessary?
Certainly. The bank's security camera footage shows the last customer on October 30th, 2019, leaving at 5:23 p.m., and Cassidy Sutton, the manager of the bank, leaving at 5:31 p.m., both via the main entrance, which is located at letter B on the map. Between 5:35 and 5:50 p.m., Parker Barrow repeatedly appears on screen in the lobby area, but does not appear again after 5:50 p.m. At 6:05 p.m., the security camera, located at letter M, is moved. The footage does not show who moved it, and it stayed in that position until after the robbery occurred.
Thank you. Co-counsel, you can take that down now. Agent James, do you know how the co-conspirators communicated?
Yes, I do. After reviewing Charlie Floyd's plea agreement, I discovered that the robbers had used identical flip phones purchased from Mid-Cell to communicate. The FBI subpoenaed their phone records.
And can you describe these phone records?
Certainly. According to investigative results, 3 of the numbers on the phone logs belonged to Charlie Floyd, Laurie Boozmail, and Jane Doe respectively, and a 4th co-conspirator, the inside source, had the 4th and final number on the logs.
And who have you possibly considered to be such an inside source?
Well, Parker Barrow and Cassidy Sutton are the only 2 people who could possibly fulfill that role, though Parker Barrow has more incriminating evidence against them.
Thank you, Your Honor. No further direct questioning at this time.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Thank you. Now, Agent James, I want to begin with talking about what's missing in your investigation. Near the end of your investigation, you obtained a warrant to search Parker Barrow's house, correct?
Yes, Parker Barrow's house, car, and computer.
And Agent James, you executed this warrant and searched his house
Yes, I did.
and his cell phone
Yes.
and his car,
Yes.
as well as his computer.
Objection, Your Honor, asked and answered.
May I respond?
Counsel, yes, may you please respond?
I did not ask about his computer before, but about his cell phone, I believe. So this would be a different question and not asked and answered.
May I respond briefly?
Yes.
My witness has already clarified that they searched the car, the computer, in a separate question asked by Mr. Uresk. Therefore, this is asked and answered.
May I respond?
Not at this point, not on this. I overruled the objection we allow cross-examiners a little bit of leeway here. If it becomes excessive repetition, you may renew the objection.
Thank you, Your Honor.
Now, you searched his computer, correct?
Yes, that is correct.
But you found nothing tying my client to the robbery.
No, I did not. However, when I spoke to Parker Barrow's father,
could you please just reply with a yes or no question? It would make it so much easier to move on with this examination.
Okay, so you're asking me to, you're raising an objection that the witness is not.
No, Your Honor.
The question now.
I was just asking the witness to answer with a yes or no question. That's all.
Well, if you're asking it for, you can ask the witness to answer yes or no. But I was a little unclear. Are you asking me to do anything?
No.
Okay. Then proceed with your questions.
Now, Agent James, there was another suspect in this case who you didn't get a warrant for, correct?
that is correct.
And this suspect was Cassidy Sutton.
Yes.
And you didn't search her home, correct?
No, I did not.
Or her electronic devices?
No.
And you didn't search her car?
That's correct.
Even though, like you mentioned on direct examination, Sutton was an employee at the bank.
Yes, that is correct, but Sutton was not there at the time of the robbery, so we didn't see Sutton as much of a viable suspect as Parker Barrow.
So without fully investigating Sutton, you disregarded him as a suspect.
I believe that we investigated Sutton enough to determine that Sutton was not a viable suspect.
Now, Agent James, you didn't even apply for a warrant.
That is correct.
Now, there was also a cleaning crew with a copy of the key to get into the bank, correct?
Yes, that is correct.
But you didn't get a warrant to search their houses?
No, because there was no evidence that they were there at the time of the crime.
And you know this because you questioned them about this, correct?
No, I did not question them, but based on the evidence that I found at the bank, it was far more likely that Parker Barrow and Cassidy Sutton were our suspects.
Agent James, did you investigate the cleaning crew at all?
No, because as I said before, they were not very likely suspects.
Thank you. So you dismissed them as a possibility in your case, just like Sutton.
That is correct.
Now, Agent James, let's talk about something else that is missing. Can we agree that in a bank robbery investigation, financial records are an important piece of evidence?
Sometimes, yes.
Especially when the main motive that you have for Parker Barrow committing the crime is that she was low on money and needed more?
Oh, well, yes, then financial records may have been helpful in this case.
But you never obtained financial records from Parker Barrow or anyone else in the case?
No, I was unable to.
Now let's talk about the security camera. You mentioned on direct examination that this camera was altered to point towards the ceiling at 6:05 p.m., correct?
Yes, it was changed to point towards the ceiling at 6:05 p.m. on October 30th.
But you did not see who moved the camera.
No, unfortunately, the footage did not capture that.
You assumed it was Barrow because of a fingerprint you found on the camera.
Yes, and because Parker Barrow is the only employee we know who was there at the time when the camera was moved.
You didn't even consider the possibility that the perpetrator could have used gloves?
Well, yes, I did consider that possibility, but the fact that Parker Barrow's fingerprint was on the camera makes a strong case for it being Parker Barrow having moved the camera.
So to be clear, you did consider that as a possibility?
Yes, that's correct.
And you didn't mention these ideas as part of your reasoning in your conclusion, in your affidavit, correct?
That is correct.
And you didn't look for gloves in the area?
I believe we searched the area, but we weren't looking specifically for gloves. We were just looking for any evidence.
Did you check for latex residue on the camera?
No.
Did you ask people if they had seen anyone at the time of the robbery with gloves on? Or
No.
before? Did you check for Parker Barrow's fingerprints on any of the brooms in the utility closet?
No, I did not see that as being necessary.
And using gloves or broom could have been a possibility, could have been one of the possibilities for not leaving fingerprints on the camera when moving it, correct?
It could be a possibility, but I would think using a broom would be pretty hard to readjust the camera.
Now I want to talk about how you got the security footage. To begin with, you received the security footage on November 1st, correct?
Yes, I did.
And the robbery was on October 31st, the day before.
Yes, that's correct.
So to be clear, you didn't get the security footage until the day after the robbery.
That is correct.
And you received it from one of the suspects in this case, Cassidy Sun.
Yes, who is also the bank manager of the bank, so, excuse me, the manager of the bank, so they're the person with the access to the security footage.
Thank you, Your Honors. No further questions for this witness at this time.
Redirect examination, Mr. Lester.
Briefly, if I may.
You may take whatever time you need.
Your Honor, may I proceed?
You may.
Agent James, how have you determined what you know about this case?
Through a thorough investigation.
And can you describe your investigative process?
Well, we entered the bank, we searched the bank thoroughly, we went over the security camera, went over the security footage the next day, searched Parker Barrow's house and car.
Yeah, thank you, Your Honor. No further redirect at this time.
Mr. Ursak, any further cross-examination?
No, Your Honor.
Okay. Thank you, Ms. James. You're excused. Will the prosecution call its next witness, please?
Yes, Your Honor. The prosecution calls Charlie Floyd.
Okay.
May I proceed?
Just a minute. Let's get the cross-examiner up on screen. Okay. Now we seem to have more than we need.
Yeah.
The cross-examiner on my list will be.
Oh, it seems that they've solved the problem, Your Honor.
Okay. So just to confirm, Mr. Hatch, you'll be doing the cross-examination.
Yes, Your Honor.
Okay. Thank you. Then let's proceed.
Thank you, Your Honor. Please introduce yourself to the court.
My name is Charlie Floyd.
And where do you live?
I'm in prison.
Why?
Well, I'm serving a sentence for an armed robbery I committed at the Third National Bank.
And did you work at all before prison?
Yeah, I was a server at this grimy diner.
Where was this diner?
It was a all-night diner in Fairview, Midlands, called the French Toast Chalet. I put in so many shifts, I could never make enough dough.
Let me direct your attention to early October 2019. What happened around then?
I was outside the restaurant, I was on break, and then this woman, she walked up to me and she was like, "My name is Rose," but that clearly wasn't her real name.
And did you...
Objection, Your Honor. Speculation to the last answer the witness gave may be heard.
You may.
Your Honor, actually, I'd like to change my my objection to lack of foundation, because there's been no foundation laid to show why this witness would know that's not her real name. I also object to hearsay with the statements that she told the witness.
Okay, counsel, would
First,
you respond?
First, I'd like to respond to your hearsay objection. Under exception under Rule 804, the declarant is unavailable, specifically the A51 exception. Ms. Doe is unavailable to be at this trial, and she has a Fifth Amendment privilege not to testify.
Let's handle that question. First of all, Mr. Hatch, you would want to respond to Ms. Harkey's reliance on Rule 804A.
Your Honor, I stand by my objection. She's still creating a statement that can negatively impact the jury.
But we need your response to Ms. Harkey's reliance on an exception.
You'll give me just a second.
804A.
804A51.
Your Honor, I find this exception acceptable, and I take back my hearsay objection to that point.
Okay. Okay, you have a second ground for your objection?
Yes, my second question will lay the foundation needed.
Okay.
Your Honor, may I respond?
So as to how this witness would know, you're saying that the question is how this witness would know that the person who identified herself as Rose was going under an assumed name.
Yes, Your Honor.
Okay, and you say you'll lay that foundation.
Yes, Your Honor.
Okay, but the witness has already testified to that fact. So shouldn't I strike that part of her testimony until you have laid the foundation?
Sorry, Your Honor. Ms. Floyd will show how they know Rose in the next question.
Okay, but at this point, I should strike the part of her testimony that is, because at least at this point, there's no foundation.
May I rephrase the question, Your Honor? Or yes, the answer may be stricken from the record.
Okay, so on the second ground, I will sustain the objection, striking that part of the answer that reflected the witness knowing that the use of the term Rose was and assumed was not her name. I do note at the beginning of the trial, there at least was an agreement that this person would be referred to as Jane Doe. We might usefully use that name for purposes of reference. Counsel, you may proceed.
Thank you. Let me direct your attention to early October 19. How were you able to identify who is now known as Jane Doe?
I recognize this woman back on the east side from this underground gambling ring. I went there sometimes until the buying got too steep and I had to dip.
Your Honor, permission to display for opposing counsel and the witness what has been marked as Exhibit 10.
Any objection, counsel?
Your Honor, I have no objection to this exhibit being shown.
Okay. Ms. Harkey, you may display the exhibit to the witness.
My co-counsel is displaying the exhibit.
Okay.
Now, Ms. Floyd, what is this?
This is a sketch of Jane Doe.
And would you say that it's a fair and accurate representation?
Yeah, it's fair and accurate.
Your Honor, I move to admit Exhibit 10 into evidence.
Any objection, counsel?
No objection, Your Honor.
Exhibit 10 is admitted into evidence.
May I continue?
You may proceed, Ms. Harkey.
After Rose approached you, or for the purposes of this trial, Jane Doe, did you speak with her?
Yeah. She asked me if I wanted to do a little better, that she had some work that could use my expertise. I thought about it for a second and I realized if I didn't say yes, I could be in a really bad spot, so I agreed.
And after that?
She gave me a burner phone and she left.
Your Honor, permission to display for opposing counsel and the witness what has been marked as Exhibit 6?
Yes, you may display the exhibit.
Now, Ms. Floyd, what is this?
This is a photo of the burner phone that Rose gave me. Or
And-
Jane Doe.
And would you say that it is a fair and accurate representation?
Yeah, it's fair and accurate.
Your Honor, I move to admit Exhibit 6 into evidence.
Any objection, counsel?
No objection, Your Honor.
Exhibit 6 is admitted into evidence.
Thank you, Your Honor. Now, Ms. Floyd, let me direct your attention to October 23rd. What happened that day?
That's my birthday. Also, I received a call on the burner phone that Jane Doe gave me, telling me to meet her in the parking lot by the Midlands Marina at 11 p.m.
And did you comply?
Yeah, I pulled into the parking lot and she was already there with some woman I didn't recognize.
And what happened during this meeting?
She introduced me to her friend, Miss Magenta, and said that the three of us were gonna have a very profitable arrangement. And then she went into detail about her plan.
And what was this plan?
We were gonna hit the Third National Bank on Halloween morning, spooky, because she had it on good authority that a large cash deposit is made every Tuesday around 11 a.m. Our only job was to go in, wave some guns around, make a little commotion. That was mostly gonna be for show. And then I'd walk out with a bag of money.
Ms. Floyd, now let me direct your attention to Tuesday, October 24th. What happened that day?
Rose, Jane Doe, told me she wanted to scout out the bank on the 24th. So I pulled on my cap, put on some Ray Suns, the cool glasses, and then I walked to the Third National Bank.
And were you instructed to look for anything in particular?
Yeah, I was supposed to pay attention to three things. Uno, dos, tres. Okay, uno, that somebody's making a big deposit at that time. Dos, how many bank employees I could see. And tres, see if any of the bank employees seemed nervous.
Now, Ms. Floyd, let me direct your attention to the night of Saturday, October 28th. What did you do that day?
I drove back to the Midlands Marina at 10 p.m. and I described everything I saw on Tuesday to Jane Doe. That there was this man that made the cash deposit. I saw Parker Barrow and Cassidy Sutton working, and then Barrow seemed a little nervous compared to the many times I'd seen him before looking up at the camera and stuff. Something that caught my eye was that Barrow had a flip phone on the counter, and it looked just like the flip phone that Jane Doe gave me and Magenta.
Did Rose say anything after you told her about what you had observed?
Yeah, after I gave my whole spiel, she was like, "It sounds like my inside source was right about that deposit."
And did you have any concerns before the robbery?
Yeah, and I mentioned them to Rose. Jane Doe, my bad. And she said not to worry because of her inside source. She even said that her inside source was Barrow.
Now, Mr.
Objection, Your Honor.
Please state the ground.
Objection, hearsay pursuant to Rule 801. May I be heard?
Let's begin with you. Tell me what the hearsay statement was.
Yes, Your Honor. The statement that Jane Doe gave was that Parker Barrow was the inside source.
Okay. Counsel, would you respond to the hearsay objection?
Yes, although Rule 801 describes hearsay, there is an exception under Rule 804 that the declarant is unavailable, specifically the A51 exception. Ms. Doe is unable to be at trial, and she has a Fifth Amendment privilege not to testify.
Your Honor, may I respond?
I expect you to.
Your Honor, the Jane Doe is not exercising her Fifth Amendment rights because we cannot find Jane Doe. That's the reason she's not in trial today, and so she's not exercising any of her rights, and thus it does not fall under this exception.
I'm a little confused. All I heard was that Jane Doe is unavailable, and based upon that, counsel for the government is claiming that her testimony is admissible under Rule 804A.
Your Honor, well, it's true
is that a fair summary?
Well, it's true, Your Honor, that she is unavailable. That second part of the amendment, that she's exercising her Fifth Amendment rights, does not apply in this case because she is not.
Well, is that part of the rule?
That she has to exercise her Fifth Amendment rights?
Yes, I don't recollect. Does the rule refer to that the only circumstance that the person who's unavailable has to exercise their Fifth Amendment rights?
If you'll give me 1 second, Your Honor, to find the rule.
Your Honor, I'd be willing to withdraw the bit that I added about the Fifth Amendment. However, I do stand by my previous statement that the declarant is unavailable.
Okay. So as I recollect the rule has a number of circumstances defined as what would make a person unavailable, one of which includes the person exercising their Fifth Amendment privilege. What counsel has just told me is she's not relying upon that particular part of the rule. So we have to go back to the simple fact that she's not available physically because she hasn't been caught, has not volunteered to come into the courtroom. So we need your response to that particular described exception.
As to, are you speaking to me, Your Honor, or the prosecution?
Yes, now I'm now speaking to you. I'm trying to be clear in my mind about where we are. And at this point, where we are is we need you to specifically respond to the claim that 804A, 1 is it, subpart 1, makes the witness unavailable and therefore the hearsay statements by the witness admissible at this trial.
Yes, Your Honor, it's true that they are not present and it would fall under that exception.
So you are going to withdraw your objection?
Sure, Your Honor.
Are you or are
I am.
Okay. Now I'd like to say at this point, I will overrule the objection based upon counsel's statement. I would state to both parties that you need to look at the Rule 804 carefully because it in fact does not a general warrant to make admissible the hearsay of a person who is not available. Please read the rule carefully. Having proceeded with this, we will proceed with having the witness with the objection having been overruled based on the argument we've heard.
Continue, Your Honor.
You may proceed, Ms. Harkey.
Now, Ms. Floyd, let me direct your attention to Tuesday, October 31st. What happened that day?
That was the day that we robbed the bank. I slipped on my mask, headed out my front door, and walked to the Third National Bank. I sauntered around in the parking lot for a bit, pretending to talk on my phone, and then I saw Foley walking into the bank. At the same time, Jane Doe pulled up in the parking lot and Magenta got out of the car, and then we walked in.
And what happened when you walked inside?
I saw that Foley had already handed over the money. Magenta was approaching Barrow, and there was no one else in the bank, not even the manager. The security camera was even pointed up at the ceiling.
And what did you do?
I shouted, "Everybody, be cool, this is a robbery." I pointed to the gun I was carrying, and then I quietly whispered to Foley, "Don't worry, you won't be hurt. Give me your phone and sit down quietly in that chair."
And what did Foley do?
Foley was trembling, and he complied. I made sure not to point my gun at him, and then I told Foley, "Count to 100, one of those this, whatever comes after that, and then you can leave."
And after that?
I looked over at Magenta and Barrow. They looked very calm. Barrow then handed Magenta a large bag, and I could see it was full of money.
And did the police ever come to the scene?
Yeah, out of nowhere, I turned around, and there was this police officer with his gun drawn. He was like, "Police, drop your weapons." I was caught. I'm not stupid. So I put the gun down on the ground, and then Magenta dropped her gun and the bag of money, too.
And were you arrested?
Obviously. But when I walked out into the parking lot in my handcuffs, Jane Doe's car was gone. The police arrested me and Magenta on October 31st. So I guess they didn't know about the inside source, which ended up being good for me.
And were you ever questioned by the police?
Yeah, the police asked me if I knew where Rose went. You know what I'm saying? No clue. Her absence has been disappointing to the police and the prosecutor since she was kind of the big fish around here. But I think everyone's pretty happy I could tell them about Barrow being the inside source.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. May I begin?
You may.
All right, now, Ms. Floyd, I'd like to first talk about why you're here testifying in court today. Now, it's true that before you came to trial, the prosecution offered you a plea agreement.
Yeah, that's true.
And when you were told about this plea agreement, you were told that you needed to point the finger at someone.
I'm just providing the truth.
And you had to point the finger at someone because you weren't able to give any evidence as to where Jane Doe went.
Objection, attack of character.
Counsel, what rule are you relying on?
Excuse me, improper character attack. That is my objection.
And my question is, what rule are you relying on?
I'm not relying on a specific rule. It's the attorney for mock trial rules of evidence. Rule 493. Excuse me. I'm sorry. 403.
403. 403 says nothing about character that I recollect. Could you look at if you're going to have a character, it's going to be either rule 404 or 608 would appear to be appropriate, possibly applicable to this in this case.
It's more so unfair prejudice. The statement is more judgmental.
Okay, so your objection is it's more prejudicial than probative of anything. Okay, so we're not really dealing with character evidence.
Excuse me, Your Honor, I misspoke.
Okay, Mr. Hatch, would you respond?
Yes, Your Honor. So I'm failing to see what prejudice this can cause in the minds of the jury, and as opposed to the fact that this witness is laying out and in this question that this is why she's testifying, and it goes to each of the points in the case today, each of the case that the prosecution brought up in their direct examination. And so I believe that the facts brought up far outweigh any prejudice that will be brought up in the minds of the jury.
I'm a little unclear, just, what is the evidence going, why are you offering that? What issue in this case does it potentially relevant to?
Your Honor, I'm showing through this line of questioning that Ms. Floyd is testifying against Ms. Barrow and she had to do this in order to accept this plea agreement, and that would alter her testimony. So Ms. Barrow may not have even been involved in the case. However, she still would say that she was to accept this plea agreement.
So if I can summarize, it goes to her credibility as a witness?
Exactly, Your Honor.
Okay. Ms. Harkey, would you respond to the, at this point?
Yes, Your Honor. I was objecting specifically to the fact that opposing counsel was re-asking the question who specifically the prosecution asked Ms. Floyd to point a finger at.
I'm sorry, Your Honor, if the opposing counsel could restate their reasoning, I was unable to hear any of it.
Yes, pardon me, there seemed to be a technical glitch there. We did not get a very clear audio on your response.
Can you hear me now?
Yes, I can hear you now.
Okay. I'm objecting to the fact that it will not provide any helpful evidence. It will only paint Floyd as a crook and unreliable.
Okay, well, that's what they told me they intended to do, and that seems relevant to the witness's credibility.
Okay, Your Honor. I withdraw the objection.
Okay. Objection being withdrawn, I will not rule on it. Mr. Hatch may proceed with his cross-examination.
And in order to accept this sweetheart deal, you had to point the finger at Ms. Barrow.
I didn't have to point a finger. I'm just telling the truth, just telling them what I heard.
And you had to testify for the prosecution.
Well, yeah, that's why I'm here.
Against Ms. Barrow.
Yep.
Now, Ms. Barrow, I want to clarify a few things. First, how your co-conspirators may have known Ms. Barrow's name. Now, a week before the robbery, you went to the bank to scout things out.
Yep. Mm-hmm.
And you saw Ms. Barrow working there?
I did.
And she had a name tag on.
Yeah.
And it read Parker Barrow.
Yeah, I saw that.
It had her full name on it.
Yeah.
Okay, thank you. Finally, I want to talk about one last thing. Now, on direct examination, you mentioned that you believed that Ms. Barrow was the inside source because of some statements made. I want to talk about that. First, did you ever meet the inside source in person?
No, I didn't need to.
In fact, you had met Ms. Barrow several times.
Sorry, can you repeat that?
Now, you had met Ms. Barrow several times.
Yeah, I go to the bank.
And she had never acted any differently towards you?
Not me specifically.
She didn't say anything differently to you when you were there?
Not me specifically. There was no need.
In other words, she was acting completely normal.
Well, I wouldn't say completely normal.
But, and you never even talked to this inside source, did you?
Well, I mean, what relevance does that have? No, I didn't.
And not even on the phone?
I didn't need to.
Thank you, Your Honors. I have no further questions for this witness at this time.
Redirect examination.
Not at this time, Your Honor. Thank you.
Well, this is the last chance you get. So is there any redirect examination?
No, Your Honor. Thank you.
Thank you, Ms. Floyd. You're excused. Will the prosecution call its next witness, please?
Yes, Your Honor. The prosecution would like to call Cassidy Sutton to the stand. May I proceed, Your Honor?
You may proceed.
Please introduce yourself to the court.
My name is Cassidy Sutton.
And where do you currently work at?
I work at the Third National Bank of Midlands.
How long have you worked at the bank?
I've worked there since 2008, so about 12 years.
And what are some of your past occupations in the bank?
I worked as a teller for 4 years, and in 2010, I was promoted to private banker.
What is a private banker?
It's basically a teller for wealthier clients.
And currently, what is your job at the bank?
I am the bank manager.
How long have you worked as the bank manager?
I've been in that position for nearly 3 years.
And what do you do as a bank manager?
I'm the one in charge of the building, security, personnel, customer satisfaction, and record keeping.
Now, Ms. Sutton, let me direct your attention to the night of October 30th, 2019. What were you doing?
I was checking the cash on hand, the safe deposit boxes, the vault, and the teller's boxes to make sure they were balanced and emptied.
And what did you do next?
After that, I checked the security system. I have a routine to check the security system every night before I leave. Our security system's pretty user-friendly.
What do you mean by user-friendly?
We have a main control panel in the security office, and you check the status of the entire system at once.
And from the control panel, what are some specific things you can check from it?
I can check the camera and make sure it's recording. I can also check the vault and the cash boxes. Additionally, I can check if both the silent alarm and the perimeter system are online.
And what does the silent alarm and the perimeter system do?
They are both set to dial 911 if tripped.
And what did you conclude about the security system of the bank?
Everything was the way it should be. The camera was pointing in the correct direction and it was recording. The silent alarm was online, so there was no reason the alarm couldn't have been tripped the next day.
And what was your feeling about the bank that night, if any?
I was extra anxious about the bank because I was planning to be gone.
Why were you feeling anxious about being gone?
We'd been short-staffed that week, so I knew Barrow was going to be alone on the floor. I was worried about it, but Barrow insisted that it would be okay.
And since the bank has been short-staffed, have you made any attempt to bring in new employees?
Yes, we'd been short-staffed because my assistant manager was out on parental leave and the other full-time teller was out sick with the flu all week. I tried to bring in part-time tellers throughout the whole week, but sadly on the night that the bank was robbed, no one was available.
And why exactly were you planning to be gone?
It was actually Barrow who suggested I take some time off in the first place.
And why did Ms. Barrow say that?
Objection, Your Honor. Speculation.
Please tell me what the speculation is.
Your Honor, opposing counsel is asking this witness to testify as to why another witness, the defendant, said something, which is them testifying as to the mental state or thoughts or reasons of another person, which would be speculative, pursuant to Rule 602.
Mr. Cho, would you respond?
Yes, Your Honor. Now, Ms. Barrow actually tells Sutton about why he believes that Sutton should be gone the next day. And that's actually my next question. Therefore, it's not speculation because Barrow specifically told Sutton why Barrow believes such a thing.
May I respond?
You may.
Your Honor, in which case, if opposing counsel wants to use that foundation to establish that it's not speculative, then I'm going to switch my objection to lack of foundation because they haven't laid that foundation in court today. And if they do lay that foundation, there's possible objections that come up. So them skipping that foundation is unfair to us being able to judge whether or not it's a fair use, fair guess for them to make based off the information they have. Therefore, this is not, the proper foundation has not been laid and needs to be laid before they can offer this statement in court.
Counsel?
Can I ask the opposing counsel what exactly they're talking about of lack of foundation in my statement?
Well, let me ask you, what is the question?
The question is, why did Ms. Barrow believe that Ms. Lynn should take a day off?
Okay. And how would the witness know that?
Because at the same,
have you laid a foundation for why the witness would know that?
Because the next question specifically states that why Ms. Barrow told Sutton.
Okay, I want to sustain the objection. You said we've got the horse before the cart before the horse. please lay a foundation that if you're basing it, as I understand, on Mr. Barrow stating something, then you should first ask what Mr. Barrow said on the subject.
Sorry, Your Honor. Yes, Your Honor, may I continue?
You may now proceed.
Now, Miss Sun, did Miss Barrow say anything about you being gone?
Yes, Barrow believed I needed a mental health day. She was always commenting about how stressful
Objection, Your Honor. Speculation pursuant to Rule 602.
The witness, I want to sustain the objection. We've had the discussion already. The witness should be testifying as to what Mr. Barrow said, and should not be speculating about anything else. That may
Your
be.
Honor, may I respond, Your Honor?
Yes, you may.
Now, everything that Miss Sutton answered as this question is actually based on Miss Barrow's answer. So, and what actually Miss Barrow told Miss Sutton about being gone. Therefore, it is not speculation. Miss Sutton is not making up facts about what she believed, about what Miss Barrow said. It is actually what Miss Barrow told Miss Sutton about Miss Sutton being gone.
But it's already argued by Mr. Christensen, so I'm not going to ask him to. Until the foundation is laid, you can't have the witness testify to the fact. So you just need to lay a foundation showing effectively what Mr. Barrow told the witness. So let's ask. Can you ask the witness what Mr. Barrow said on the subject, and then we'll get Mr. Barrow's statement.
Yes, Your Honor. Miss Sun, what did Miss Barrow say about you being gone the next day, if any?
Well, Barrow told me my bad. Barrow had always been commenting about how stressful my job seemed, so he believed I needed a mental health day.
And what was your reaction?
Objection, Your Honor. Speculation pursuant to Rule 602. Just this time to the last portion of that answer, and if we just want to strike that rather than the entire answer, that's what I would request of the court.
Okay, what was the last portion that you want struck?
The last portion of the answer wherein the witness said, Barrow believed I needed a break.
Okay. Mr. Cho, do you want to respond to that?
No respond, Your Honor.
Okay, I will grant the request to strike that part of the witness's testimony.
Yes, Your Honor. May I continue?
You may.
Now, Miss Sun, what was your reaction to Miss Barrow telling you this?
I was just planning to go to the dentist during my lunch hour, which is what Barrow had recommended to me, but Barrow insisted that it would be better for me to take the whole day.
Now, let me direct your attention to October 31st of 2019. What did you do that day?
I slept in until about 8:30. The bank opens at 9, so I called Barrow at the bank at 8:55 just to make sure everything was running smoothly and I didn't need to come in. Barrow said everything was fine and that I should relax and take the day.
What did you do next?
I made breakfast and I turned on the TV. Later, when I was about to turn off the TV, a breaking news report flashed on the screen. It showed the bank and it said that there was an unfolding situation.
And what was your reaction to this news?
I rushed to the bank as quickly as I could, and I helped the local police and the FBI by showing the security footage from October 30th and 31st, 2019.
And what did the security footage consist of?
The footage for October 30th, 2019 shows me leaving the bank before 6 p.m. At 6:05, the camera was tilted up, so it only captured the ceiling. Barrow was the only employee at the bank when the camera was moved.
Your Honor, I would like to request permission to display to the court what has been previously submitted as Exhibit Number 1.
Permission granted.
Now, Ms. Sutton, can you tell the court what the footage show about Ms. Barrow and relating to the map?
From 5:30 to 5:50, Barrow appeared a few times on the screen doing normal end-of-the-day activities. At 5:50, Barrow left the teller area E, crossed the lobby toward the employee hallway F. The camera lost sight of Barrow as she walked under the camera, which was the last time Barrow appeared on the footage.
Thank you, co-counsel. That is all I need from Exhibit Number 1. Now, Ms. Sutton, this camera you mentioned earlier, did it show anything about the robbery?
The camera did not record anything from the robbery because it was pointing upwards until we fixed it later.
And this silent alarm and a perimeter system you talked about earlier, did it do anything during the robbery?
I get a report every time the silent alarm is tripped, but I got no report at all from October 31st. I even double checked with our security company. The silent alarm was not tripped.
Now, Ms. Sutton, do you have anything else about Miss Barrow that you wish to tell the court?
I think it's a bit too convenient that Barrow was alone on the floor that day.
How was it too convenient?
Barrow had been acting suspicious for about a week prior to the robbery.
And how is Miss Barrow acting suspicious?
Whenever we would talk, Barrow would always look around the bank, especially in the direction of the security camera. Also, I'm pretty sure I saw Barrow with the lady from the drawing last summer. I think it's called Exhibit 10.
Your Honor, I would like to request permission to display to the court what has been previously submitted as Exhibit 10 as a visual aid.
Permission granted.
Miss Sutton, is that the drawing you're talking about?
Yes, that's the one.
Thank you, co-counsel. That is all I need from exhibit number 10. And Miss Sutton, could you tell us more about Miss Barrow and the person in exhibit 10?
Yes, it was summer of 2019.
Objection, Your Honor. I just want to clear something up with the previous exhibit. They showed it to the witness and used it on the record, but didn't admit it. It was my understanding they were going to proceed to admit it, but if they were just going to show it to the witness like that, I would object and ask that it either be admitted or be stricken from the record that it was used and the witness answered that question about it.
Okay, this is at least the second time we've seen it. Is there has it been admitted into evidence or not?
It has been admitted, Your Honor.
In which case I would withdraw my objection, Your Honor. My apologies.
Okay, so the exhibit having been admitted, you've withdrawn the objection. I don't have to then make a ruling. You may proceed.
Ms. Sutton, do you want me to repeat the question?
Yes, please.
Now, could you tell us more about Ms. Barrow and the person in exhibit 10?
It was summer of 2019, and they were both outside Hans Hoagie's house, sitting at one of those little metal tables. They were both facing the bank. I remember thinking it was weird.
Why was it weird?
Well, normally, Barrow sat alone reading a book or a magazine, but he was never with a friend. I went to the Hoagie house later in Barrow's lunch hour, and I was surprised to see Barrow still sitting there.
And what was Miss Barrow doing?
She was staring at the bank while the lady talked. When Barrow came back from her lunch hour, I asked, "Who's your friend?" Barrow looked at me a little funny before telling me it was nobody.
And lastly, have you been asked anything relating to a phone?
Yes, the police showed me a phone, which I think was Exhibit 6, and they'd asked if I'd seen it before. I'm pretty sure I saw Barrow staring at a phone just like that the day I saw Barrow with the lady.
Your Honor, one last time, I would like to request permission to display to the court what has been previously submitted as Exhibit 6 as a visual aid.
Permission granted.
Ms. Sutton, is this the phone you're talking about?
Yes, that's the phone.
Thank you, co-counsel. That is all I need from exhibit number 6, and no further questions, Your Honor.
Okay. Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Ms. Sutton, I want to begin by talking about your financial status. It's true that you went through a divorce in 2018, right?
Yes, it was really hard on me. My husband, he gained custody of all of my children, and I rarely get to see them.
And it's true that you ended up paying child support. Isn't that right?
Yes, I pay child support for my kids.
Child support for all 3 of your children.
Yes.
And you also pay spousal support. Isn't that right?
Yes, I do.
Now, you would say that this financial burden is a huge part of the reason why it's been so rough on you. Isn't that true?
Yes, that, but also I rarely get to see my kids, and I miss them so much.
Now, lucky for you, you're employed, right?
May you repeat your question?
You're employed. You work at a bank.
Yes, I work at a bank.
You work around a lot of money, right?
Yes, I do.
Let's talk about that job. It's true that as manager, you run the security system at Third National Bank. True?
Yes, I do.
You know the camera system, right?
Yes, I do.
There is only one security camera in Third National Bank.
Yes, there is.
And you've reviewed security footage before, right?
Yes, all the time.
With that, you know what portions of the bank show on camera footage and what portions of the bank don't show on camera footage. Isn't that right?
Yes.
Now, it's true that you also provided the security footage to Agent James. Isn't that right?
Yes, I did.
It's also true that you were told you were a suspect for the inside man of the robbery. Isn't that right?
I was told that, yes.
And that the other suspect was Parker Barrow, right?
Yes.
Let's make a timeline with these two pieces of information. It's true the bank was robbed on October 31st, correct?
Yes.
In the morning.
Yes.
And that same day, on October 31st, you were told you were a suspect, right?
Objection, Your Honor. Asked and answered. May I be heard?
You may.
Now, in the past questioning, the past question of the opposing counsel, it has already been established that the Miss Sutton was called as a suspect. Therefore, that question is not valid anymore.
May I be heard?
May I hear a response?
Yes, Your Honor. The previous line of questioning was to establish the fact that she had, in fact, been identified as a suspect. But this line of questioning is establishing a timeline as to when that happened, because as you'll see throughout the rest of this line, the relationship between when that happened and when other events occurred is extremely significant in showing the bias that this witness had in the investigation of facts they gave to the FBI. So this is not about whether or not she was a suspect, but when she was notified she was a suspect.
Mr. Cho, would you respond?
Yes, Your Honor. Now, yes, it is true that it's part of the time, but both of the questions have the exact same ideas. It's asking if Miss Sutton was a suspect or not, and therefore it's already been asked and answered.
Okay, as I ruled with the previous objection, I give cross-examiners a little leeway here in terms of repetition. I will do so again here. I overruled the objection.
So Ms. Sutton, that same day on October 31st, you were notified that you were a suspect, correct?
I believe so, but I'm not certain.
And the next day, November 1st, is when you provided footage to the FBI, correct?
Yes.
So there was roughly 24 hours between when you were notified you were a suspect and when that footage was given to the FBI, right?
Yes, but if you're insinuating I manipulated the footage, you're very wrong.
Ms. Sutton, it's true that you had access to the security footage during those 24 hours?
I had access, but I didn't touch it.
And conveniently, the security footage tends to exonerate you, correct?
Yes.
Right, now, I want to talk about something else that was mentioned on direct examination. You said that the silent alarm should have gone off. Isn't that right?
Yes, everything was set the way it should be.
I want to talk about how the security system works. There's a control panel in the security office, correct?
Yes.
And that control panel tells you if the vault and cash boxes are locked.
Yes, it does.
Or if the camera is recording.
Yes.
And in particular, if the silent alarm is online or not. Isn't that right?
Yes, that's what it shows.
Now, I want to talk about how accurate it is that this security system represents things. It's true that you remember a time in the past when the control panel said the vault was unlocked, when in reality, you knew the vault was locked. Isn't that true?
Yes.
So there's no way to check to see if the control panel is representing it accurately unless you actually test that system in real life. True?
You're correct. However, we use really state-of-the-art security system. We use the same stuff the government uses. So it's really unlikely that it was incorrect.
But Ms. Sutton, on the night of October 30th, you didn't check to see if the silent alarm was running other than on the control panel. True?
Yes, but I don't think I needed to. This is a one-off chance. We never really have to use a security system.
Now, Ms. Sutton, it's also true that you can remotely activate some portions of that security system because of the support company, right?
Yes.
All you had to do was call the security company and they could reset that panel and bring the systems back online. Isn't that right?
Yes.
You had your phone with you on October 31st, didn't you?
Yes, I did.
Now, on direct examination, you told us you recognized the person in Exhibit 10. Isn't that right?
Yes, I'd seen her with Barrow previously.
it's true that you only saw that the person you claim the person in Exhibit 10 was only once in real life. Isn't that true?
Yes.
And you wouldn't say you're sure that you recognize that person, true?
Well, when I was shown the picture, I was able to tell it clearly as the same woman. I was able to remember seeing her.
Ms. Sutton, I want to make this clear. You would only say you're pretty sure it's the same person. Isn't that right?
Objection, Your Honor. Asked and answered.
Counsel, Mr. Christensen.
Yes, Your Honor. The witness did not answer my question properly. She simply referred back to a specific event and did not give a yes or no as to my question, which is very crucial for this question.
Mr. Cho.
Yes, Your Honor. In cross-question, the witnesses are not bound to just yes or no questions, and therefore, I believe that was a good enough answer to provide an answer to that question, opposing counsel, and therefore, it is not okay to ask the exact same question for clarification.
Mr. Christensen.
Yes, Your Honor. It in fact was not the exact same question. Earlier, I asked her that she wasn't, that when she said it, she wasn't sure about it, and now I'm asking to confirm that she's only pretty sure. So this difference in verbiage is pretty important because the first one says she's not certain. The second one shows us exactly how certain she was, and I want to make that distinction in court today to show the jury how uncertain she really was about the conclusion she was making.
Okay.
So I'm taking this in steps here, and that's why these questions are different, and the asked and answered objection just doesn't apply.
I'll overrule the objection, but this is the second time during your examination. I think you're getting close to the line. So please be careful not to do it again.
Yes, sir. So, Ms. Sutton, to make this clear to the members of the jury, you would only say you're pretty sure the person in Exhibit 10 is the same person you saw.
Yes.
Thank you, Ms. Sutton. Thank you, Your Honor. I have no further questions for this witness at this time.
Mr. Cho, redirect examination.
No redirect examination, Your Honor. The prosecution rests.
Well, let's not, no redirect examination. So let me first get the witness off the stand.
Oh, yes, Your Honor. I'm sorry.
Okay. Thank you, Ms. Sutton. Thank you for your testimony. You're excused. Okay. Will you now repeat for us that what the status of the defense case is?
Yes,
Or
Your Honor.
prosecution case?
Your Honor, the prosecution rests.
Okay, thank you. At this point in the trial, we'll take a 5-minute recess. Purposes of allowing judges to work a bit on their ballots and for purposes of the team members consulting with each other before we launch into the defense case. I ask the timekeepers to keep track and notify me promptly when the 5 minutes is up. Okay, let's proceed.
Yes, Your Honor.
Let's proceed on that basis. Thank you.
Your Honor, the 5 minutes are now up.
Thank you. We'll bring the court to order. Is everyone back in the courtroom from both teams? I ask at least one representative from each team to confirm that everyone's here.
Your Honor, the defense is here, present, and ready to go.
Okay, prosecution. Are you here and ready to go?
Yes, Your Honor, the prosecution is ready to proceed when necessary.
Okay, so let's proceed with the defense's case. Will you call your first witness?
Yes, Your Honor. The defense calls Harper Karpis to the stand. May I proceed?
Let me just check, Mr. Cho, you're doing the cross-examination?
Yes, Your Honor.
Okay, so we have all the participants here. Yeah, Mr. Gurisic, you may proceed.
Thank you, Your Honor. Please state your name and spell the last for the benefit of the court.
Harper Karpis. That's Karpis.
And Mr. Karpis, why are you here today in court?
I investigated the events of October 31st and made a reconstruction of the crime. I also analyzed the possibility of Parker Barrow being criminally involved.
Were you compensated for your time?
Yes, I'm being paid $30,000 for my time spent reconstructing the case. However, my compensation is not dependent on the outcome of the case.
With regards to today's case, did you reach any conclusions?
Yes, I did.
We will come back to these conclusions. For now, what is your current occupation?
Right now, I'm a professor at the Western Midlands State University. I teach criminology. It's pretty cool. I also am vice president of the Board of National Criminology Consultants.
Could you explain to the court what the National Board of Criminology Consultants is?
Yes, we're a group of consultants who establish professional guidelines for other consultants working with law enforcement to reconstruct serious crimes such as robbery, terrorism, cybercrime, even murder.
Now let's talk about your credentials. What kind of education have you received for your line of work?
I received a Bachelor's of Arts from the Midlands Technological and Agricultural College. I have also received a PhD in criminology from the University of Midlands.
Could you tell the jury about your experience?
I have advised several international banks in the Midland areas on their security systems. I have also testified in 7 bank robbery trials, and I have helped to reconstruct over 70 high-profile crimes.
Now, Mr. Karpis, I would like to talk about your methodology in examining cases. Could you tell us what kind of processes you use for investigating different crimes?
Well, for a case like this, I use what I like to call the rule of 3. This helps me to determine whether or not an inside person was involved in the crime.
What does the rule of 3 look at?
So it looks at 3 things. The first one is the sophistication and experience of the team of robbers. The second is whether or not potential insiders fit within the profile of an inside person. And the third is whether or not the circumstances of the robbery point to an inside person.
And why is the experience and sophistication of the robbery of the criminal organization involved important?
Well, let's look at an example. If you have an experienced team of robbers here and an inexperienced team here, the experienced one is going to recognize the use of an inside person much better than the inexperienced one, and they're less likely to act impulsively. Because of this, an experienced team is much more likely to engage an inside person in their robbery than an inexperienced team.
Were there indications of this team's experience?
Judging by the way they executed the crime, they
Objection, Your
were
Honor. Assumed fact, not in evidence. May I be heard?
You may.
It has not been established that if Mr. Karpis knows what exactly happened during the robbery or what the robberies exactly did during the robbery. Therefore, this is not a valid question.
Counsel?
Yes. Seeing as Mr. Karpis is testifying today, he is, and as an expert in crime reconstruction, we have shown that he is an expert in this field of knowledge and would know about the different things within this case.
Mr. Cho, you want to add anything?
Yes, Your Honor. Now, I think the opposing counsel is not really understanding my objection, but I'm objecting to the fact that Ms. Karpis know what exactly happened during the robbery or how the robbery executed their job. I am not objecting to the fact that Mr. Karpis is an expert in criminology. I'm not objecting. I'm only objecting of how it's not been established that Mr. Karpis knows about like the execution of the robbery.
I sustain the objection. There must be some foundation showing how the witness knows what happened during the robbery. I assume it normally would be from review of various documents and information gathered by the police. It may be otherwise from personal investigation, but there has to be some foundation laid before I'll allow the witness to draw a conclusion on that.
Yes, Your Honor. Mr. Karpis, what kind of information have you received in order to establish your opinions and conclusions in court?
Well, I read the investigation of Agent Kelly James. I also read the affidavit of Cassidy Sutton, along with many exhibits, including the interview between Charlie Floyd and the FBI officer, Kelly James.
Now, would you tell us if it was likely that there was an inside person involved in this case?
I concluded that overall there was a 50% chance of an inside person being involved at all.
Now, going back to the rule of three, would you expound on the second element?
So the second part of the rule of three looks at potential insiders and then whether or not they fit within the profile of an inside person.
Well, could you elaborate on what the profile of an inside person looks like?
Of course, it looks at things like weaknesses that somebody may have. This could include substance abuse, or it could be financial issues, money problems, things like that.
Now, looking at the third element, did the circumstances of the robbery on October 31st point to an inside person?
Again, I concluded that the chance of an inside person being involved was 50%.
And who are the most likely suspects to fit the profile of an inside person?
Of possible suspects, it seems to me that the most likely are Parker Barrow and Cassidy Sutton.
And how do these suspects fit the profile of an inside person?
Well, Parker Barrow may have needed money. I don't know what it would be for. Cassidy Sutton may have also needed money to pay for her divorce. I couldn't really say because there's too much missing.
And what do you mean by there's too much missing?
Well, in Agent James's investigation, Agent James did not research any financial documents of either Cassidy Sutton or Parker Barrow. Because of that, it is impossible to determine whether one of them was more likely to have been an inside person than the other.
Is there anything else missing from the investigation of Kelly James?
One of the biggest things I noticed was a lack of investigation into all the people who had access to the bank. Now, there were 4 copies of the bank's keys. One of them was held by Cassidy Sutton, the other by Parker Barrow, and the final 2 by the security company and the cleaning company. Yet there was no investigation made into either of those groups.
And why is this a problem?
This is a problem because without investigating all the alternate suspects, we cannot say for sure whether one of them is more guilty or more likely to be the inside person than another. There's just too much missing.
Thank you, Your Honors. I have no further questions for this witness at this time.
Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Now, Mr. Karpis, in consulting bank robbery cases, you can offer unique perspective, correct?
I'm sorry, I couldn't catch the last part of that question. Could you repeat it, please?
In consulting bank robbery cases, you can offer unique perspective, correct?
Yes, I can.
And that's because you're a reformed robber?
Yes, many people would say that having a criminal record is a disadvantage, but I actually find it to be a huge advantage because I can think just like the very people that I'm trying to catch.
And when you were a robber, you were part of the ring that robbed 17 banks across Midlands, correct?
That's true.
And now about the camera of the bank. It is possible that Vera manipulated the camera to point it toward the ceiling?
I mean, obviously it's possible. It's just there are too many other possibilities.
And in addition, Vera might have chosen not to sound an alarm?
That's also possible, but again, there are other possibilities. There may have been technological manipulation by outside sources.
Now, just like you said, the robbers could have modified the security system, correct?
That's true.
However, there's absolutely no evidence that the robbers possessed such a skill to do so.
That's also true. I mean, they could have had skills like that. I didn't see any evidence of that. There's just too much missing in this case.
And the fortunate timing of the robbery can indicate that there was an inside person.
I mean, that's a possibility.
And it's also the same fact, the lack of alarm activation.
Again, this could have been for a number of reasons. It's a possibility that Parker Barrow didn't trigger the alarm. It's a possibility that there was outside manipulation.
Now, if there was an inside person, there are two major possibilities, correct?
That's correct.
And one of them is Miss Barrow?
Yes, the other one being Cassidy Sutton.
And Miss Barrow's family have medical issues, correct?
I couldn't say.
So they could possibly need extra money?
I mean, anybody could possibly need extra money, but there was no evidence of Parker Barrow needing extra money.
Now, like you said, Sutton's also a possibility, but however, it's less plausible for Sutton to be an inside person, correct?
I concluded that Sutton being a possibility was less plausible because Miss Sutton was not at the bank at the time of the robbery. However, Sutton is still a very distinct possibility.
Thank you. No further questions, Your Honor.
Redirect examination.
Yes, briefly, Your Honor. Now, Mr. Karpis, why are you not sure about the financial status of Sutton and Barrow?
I'm not sure of their financial status because there was no investigation made into their financial status. There is just too much missing.
And who led the investigation?
Agent Kelly James.
Thank you, Your Honor. No further questions.
Any further cross-examination?
Yes, Your Honor, briefly.
Take as much time as you need.
Now, Mr. Karpis, back to talking about the financial position. You don't know the exact position where the financial position of Barrow's family, correct?
No, I do not.
However, you know by fact that Barrow's family have medical issues.
Objection, Your Honor. This is beyond the scope of my redirect examination.
Counsel, Mr. Cho,
Mayor-
what
Yes,
did
Your Honor.
what was said during the redirect that was related to your topic?
Your Honor, I'm talking about the financial situation, and medical issue is definitely a part of that can affect the medical financial position of
May I
the
But you're limited to what was the subject matters, at least, that were raised on redirect. You're now not doing the first direct cross-examination. You're doing the second one.
Yes, Your Honor. I withdraw the question.
Okay.
And I have
Denied.
no further recross, Your Honor.
Okay, thank you. Mr. Carpus, thank you for your testimony. You're excused. Will the defense call its next witness, please?
Yes, Your Honor. The defense calls Mr. Jesse Hurst to the stand. May I begin?
Let's be sure we've got everybody here. Ms. Harkey, you're doing the cross-examination, I'm assume. So you may proceed, Mr. Hatch.
Please state your name and spell the last for the record of the court.
Yeah, my name's Jesse Hurst. That's Hearst.
And what do you do for a living?
I'm currently part-time employed at the post office. I used to work full-time, but now I'm only part-time.
And why do you only work part-time?
Some health complications came up, so I couldn't support full-time anymore.
Now, Mr. Hurst, today in court, there's been some confusion as to your health complications and your financial status. If you wouldn't mind, I'd like to talk about each of them. First, what were those health complications that prevented you from working full-time?
I was diagnosed with stomach cancer.
And what did you do to treat your cancer?
I went through chemotherapy in order to treat the cancer.
And was there anybody who could help you while you were adjusting from the chemotherapy?
Yeah, while I was going through my cancer treatments, my daughter, Parker Barrow, came to live with me.
Now, Mr. Hurst, I'd like to talk about both of these things that you did to help your cancer. First of all, let's talk more about your daughter. What's her name?
Parker Barrow.
And why did she move in with you?
She was just there to support me during my time of hardship of having cancer. She supported me financially a little bit and was able to help me out with anything I needed.
And are you close with your daughter?
Yeah, we've always been really close.
And now I want to talk about the second thing that you did. Did you receive specifically talking about your chemotherapy, was there anything else besides the chemotherapy that you were able to do to help treat your cancer?
So after my chemotherapy, I was declared cancer-free. So I just have yearly appointments to go and check in with the doctors and make sure that the cancer hasn't returned to my body.
And do these appointments come with medical bills at all?
Yeah, they have some medical bills, but since there's no more chemotherapy, it's gotten a lot cheaper.
Okay, and let's talk about those medical bills you had. Did you and your daughter, so you said that you were part-time employed?
Yeah, I have a part-time job.
And was your daughter ever employed while she was living with you?
Yeah, she had a full-time job at the local bank.
And was her job from the bank her only source of income?
No, she also did some wedding photography on the side. She just seemed to be really into it, and I love to support her, and so she made a little extra money off of that.
Okay, and Mr. Hurst, based off of these three different sources of income, were you able to pay each of your medical bills?
Yeah, we were more than covered. We paid for my medical bills, and we even furnished our apartment really nice.
And what is your current financial status?
Yeah, I'm doing just fine with money. My medical bills are not overwhelming me at all.
And then you mentioned that you have several appointments every year to check to see if your cancer is gone. When was your latest appointment?
It was on November 1st, day after Halloween.
Okay, and I actually want to talk about the events leading up to that appointment. First, did your daughter do anything leading up to the weeks to your appointment?
She seemed a little bit nervous, but she always is leading up to those appointments because if I was declared to have cancer again, it would be big toll on us because we'd have to pay a lot of money. But she's always a little nervous leading up to those appointments, but nothing too bad.
And Mr. Hurst, again, there's been some confusion as to your daughter owning a flip phone. Did you ever see her have this flip phone?
Yeah, I noticed that she got one, but I didn't really know what it looked like. They all look pretty much the same, but I assumed it was probably for a wedding thing or something else. I wasn't too sure.
Now, Mr. Hurst, I want to move on to the day of the robbery. Let's start with that morning. Did anything unusual happen that morning?
No, it just seemed like a normal morning. Parker headed off to work, and I got started on my daily tasks.
And did you hear anything from Miss Barrow that day?
Not during the morning, but during the afternoon, I heard about that the bank she worked at had been robbed.
And let's talk about what happened when she got home. How was she when she got home?
She seemed really shaken up, and it was probably really traumatic for her. So I made her some tea, and we decided to watch the news coverage together.
And did she get any better that night?
Yeah, she got a little better, but she was having trouble sleeping, and I could tell it took a pretty big impact on her mental health.
Thank you, Mr. Hurst. Thank you, Your Honors. I have no further questions for this witness at this time.
Cross-examination.
Yes, may I have a moment to readjust my setup?
You may.
Mr. Hurst, you are the father of the defendant Parker Barrow, correct?
Yeah, that's right.
And you and Miss Barrow are very close.
Yeah, we've always been really close.
Almost best friends?
Yeah, we've done everything together.
And you support each other however you can.
Yeah, that's right.
You enjoy buying lottery tickets, correct?
Yeah, I'll buy one. Sometimes I'll buy one and then go deposit my winnings at the bank.
And because you did not earn enough money to support yourself from your job?
Yeah, sometimes.
And your daughter works overtime to help you?
Yeah, she has a job and she also has a second job that she enjoys. And she supports me financially sometimes.
And after your health scare in 2019, your daughter came home to live with you?
Yeah, that's correct. I appreciate her a lot.
And Parker now lives in your basement living space, correct?
Yeah, that's right.
Parker has been spending a lot of time on the phone lately?
Yeah, I've noticed she's been spending a little more time than average, but it's probably for her wedding photography gig. That's what I think it is.
But you can't be sure.
No, yeah, I never asked her about it.
And when Parker was on the phone, she was talking in a quiet voice, like she might be embarrassed for you to hear the conversation?
Yeah, she seemed a little quieter, but I never asked her about it.
And you are certain that you saw Parker multiple times with a flip phone, correct?
Yeah, I saw her with a flip phone, but yeah.
And Your Honor, I'd like to request permission to display what has previously been submitted into evidence as Exhibit 6.
Permission granted.
Co-counsel. That phone looks identical to this phone, correct?
I'm not too sure. I haven't seen a flip phone in a really long time. They all look the same to me.
But you'd say it's the same color?
Yeah, it looks about the same as every flip phone.
Same model
Probably. I'm not too sure.
and design?
Again, probably all flip phones look the same to me.
Thank you, co-counsel. That's all I need from Exhibit 6. But you thought it was odd that Parker was using a flip phone, correct?
Yeah, he already had an iPhone, but I guess you want to just keep work and personal calls separate.
Because she had always had an iPhone?
Yeah, that's correct.
Thank you, Your Honor. No further questions at this time.
Redirect examination.
No, Your Honor.
Thank you, Mr. Hurst. You were excused. Thank you for your testimony. Will the defense call its next witness, please?
Yes, Your Honor. The defense would like to call Parker Barrow to the stand. May I proceed with direct examination, Your Honor?
In just a second, please. You may now proceed.
Will you please state your name and spell the last for the members of the jury?
I'm Parker Barrow. That's Barrow.
Where are you from?
I live with my dad in Midland City, Midlands.
And why do you live with your father?
A little more than a year ago, he got stomach cancer and needed someone to help take care of him, so I moved back home to help him out.
And what is your job, Miss Barrow?
Right now, I don't have a job. I used to work as a teller at the Third National Bank of Midlands, and I used to also work as a wedding photographer on weekends, but after I was arrested, the bank fired me, and apparently no one wants someone who's on trial to take pictures at their wedding, so that business went under too.
You're in court today because you've been accused of robbing the bank where you work. Do you have any reason to rob a bank?
No, I have no reason to rob a bank, and I don't even need money. There's no reason that I would throw my life away for a stupid crime like that.
What was your financial situation like in October of 2019?
Actually, things were going pretty well. We had just gotten back on our feet after paying for all my dad's medical bills. Everything was going okay, but I was still working overtime and I got a second job for weekends.
Why is it that you were still working overtime?
I was planning on finally fulfilling a lifelong dream of mine. I was going to go to Paris and spend a week exploring the Louvre and the Musée d'Orsay. I was going to spend 3 days in the Musée d'Orsay with Impressionist masters, 4 days in the Louvre with the classical masters. I was going to see the Mona Lisa, the Venus de Milo. I was going to see Van Gogh's collection, Monet's water lilies.
Ms. Barrett, thank you so much for that. With that in mind, can we talk about October 31st at this time?
Sure.
What were you doing on the morning of October 31st, 2019?
It was a pretty normal morning. I got up, got some breakfast on the way to work, and I was at the bank about 8:30.
And who else was working that day?
Usually my manager, Cassidy Sutton, will work that shift with me, but she had a dentist appointment and she could only fit it in at lunchtime. So I told her just to take the whole day off. She'd seemed really stressed lately, and so I figured she could use a break. So I told her it'd be fine for me to cover the whole day.
And around what time was the bank robbed that day?
It was about 11 a.m. I remember because Jackie Foley always brings in the same deposit on Tuesdays at 11, so it was right at the same time.
And how did the robbery begin?
I didn't even understand what was happening at first. Two people in masks came in, they waved guns around and shouted that this was a robbery, and they took Foley, who was the only customer at the time, made him sit down, and then the other robber came up to me and handed me a bag and pulled out their gun and told me to fill it with cash.
What did you do?
Well, the first thing I did as soon as I realized that it was real was I pressed the pedal underneath the desk, silent alarm, so to try to alert the police. And then I just did what the robbers asked.
Is it possible that when you tried to trigger that alarm pedal under the desk, that you missed and hit something else under the desk?
Like that it didn't press?
Yeah, is it possible that you missed the pedal?
I mean, I guess. I wasn't looking at it. The whole point of a silent alarm is to be discreet, so it's possible.
What did the robbers do after you pressed the silent alarm under the desk?
The female robber, she handed me the bag of cash and told me to fill it with the money that Jackie Foley had just brought in.
And did you fill that bag with money?
Of course I did. I was afraid for my life. She had a gun. It was no time to play the hero. I gave her what she wanted.
And when did the police arrive at the scene of the crime?
Right about the time that I gave the bag back to the robbers. They burst in and told the robbers to get on the ground.
Were the police able to contain the situation?
Yes. Yeah, the robbers, they dropped their guns on the ground and they got on the floor and the police handcuffed them and they were taken who knows where.
And where did you go after the police contained the situation?
Well, during the robbery, I tried to keep my cool. I felt almost hysterical, but I tried to keep a straight face. After the robbery left, I could feel I wasn't going to be able to keep it together much longer. So I went out to my car for a little bit. And while I was in my car, everything that I had felt during the robbery exploded out of me. I was hysterical. I haven't cried like that since I was a toddler. I couldn't breathe. I couldn't stop sobbing. It took at least 20 minutes before I even trusted myself to drive again.
Ms. Barrow, if it's all right with you, I want to take a moment and shift the gears here and talk about some of the accusations that have been made against you in court today. Is that okay with you?
Yes.
Were you in court when Agent James talked about you having a matching flip phone to the bank robbers?
Yes.
And do you carry a flip phone?
Not anymore, but around that time I had a little one, yeah.
Why'd you have a flip phone?
Mostly it was for my photography business. I mean, I just wanted to keep work and personal calls separate, so I bought a little $40 flip phone at Best Buy, and I used it for business calls.
And do you still have that flip phone today?
No, I mean, after my photography business went under, there was no reason to keep it. And there was a kid in my neighborhood that was buying her first phone, so I sold it to my neighbor for $10.
No. At this time, I'm going to display a photograph of the bank robbers' flip phones, and I want to check to see if that looks the same as the flip phone that you have. So at this time, Your Honor, I request permission from my co-counsel to share Exhibit 6 with the court.
Permission granted.
Does this look like your flip phone?
Not really. I mean, I can see how someone would think that, but they're not the same.
How is this flip phone different from the one that you had?
Well, along the edges, you can see a bit of red casing. Mine was all black. The back wasn't red. It was all black, and the inside had square buttons instead of the round circle button, and it didn't have silver on it. It was all black too.
Now, if we can put that exhibit down at this time, I want to address another accusation that was made against you in court today. Did you hear Agent James talk about your fingerprints in court today?
Yeah, I did.
And would it make sense for you to have fingerprints on the camera if you were the inside man?
If I was the inside man, like if I was involved with the robbery?
Yes, Ms. Barrow, if you were involved in the robbery, would it make sense for you to have fingerprints on the camera?
Isn't that like the first rule?
Your Honor, speculation. You're muted, Your Honor.
What is exactly is the speculation that to which you're objecting?
Your Honor, Mr. Christensen had asked, would it make sense if, therefore not testifying to fact, but instead to opinion?
Okay. Mr. Christensen?
Yes, Your Honor. Pursuant to Rule 701, this would be a fair lay witness opinion that wouldn't require any expertise. I'm simply asking her if, in her opinion, it would make sense for her to have fingerprints on the camera, which is not a crime scene question that would require expertise, so much as is her personal perception of these lay facts laid out before.
Mr. Lester, would you reply?
Yes, according to Rule 701, an opinion testimony by a non-expert witness is limited to a rational opinion. And since this witness is clearly testifying against themselves here in court today, this does not make sense. That's just my personal view.
May I be heard on that grounds?
Just a second.
Yes, Your Honor.
You know, I just want to emphasize, Mr. Lester, I'm not interested in your personal view. The question is, what does the rule provide? So relying on Rule 701.
Yes, the rule provides a rational opinion. Your Honor, this witness is clearly providing their personal opinion, which is not allowed under Rule 701.
Okay. Mr. Christensen.
Yes, Your Honor. Opposing counsel's argument is that because this opinion is irrational, that therefore it's not something that can be offered in court. However, that's just not what the rule means. And see, when the rule says a rationally based perception, it's saying something that someone can use a little common sense, look at the facts in front of them, and figure out without actually having to do an analysis, use fancy equations, or do a chemical analysis. The point of that isn't whether or not it makes sense. And as you'll see, this opinion does make sense. But it's whether or not that opinion could have been made based off of common sense and basic reasoning, which, as you'll see, this opinion very much could have. See, 701 lists two standards. One, it's based off of not technical knowledge, which is clear in this case, and two, that it's a rationally based exception, which again is clear in this case, and therefore it's not speculative.
Okay. I'm going to sustain the objection subject to the witness testifying to additional information. Rule 701 requires a rational perception. Rationality is part, perception is the other. And perception means that she observed the events as to which she is giving an opinion. So the question is, if the witness has, what perceptions has the witness given that open the door to allow this opinion? Given that, you may proceed, Mr. Christensen. I sustain the objection.
Yes, Your Honor. Ms. Barrow, if you were robbing a bank and you wanted to adjust the camera, would you leave fingerprints?
I mean, isn't that pretty basic? You use gloves so you don't leave fingerprints behind. I thought everybody knew that.
Objection, Your Honor. Speculation again.
And which statement are you objecting to the entirety of this statement or to just part of the witness's statement?
The entirety of this statement. Clearly, Mr. Christensen has just rephrased their question and this witness has rephrased their answer.
Mr. Christian, I'm inclined to agree.
May I be heard on those grounds?
I'm inclined to agree with what Mr. Lester has just said. It sounds awfully like the same. So unless you can tell me that it's different, I'll sustain the objection.
Would Your Honor like a response for me to explain how this is different?
Yes, I would.
Yes, Your Honor. See, the reason that this is different is because in the last question was asking the witness to give their perception based off of events you observed, and you ruled that the witness had not observed it. Now the question is different because I'm asking the witness what they would do, which is asking them about themselves, which is clearly something they have personal knowledge of. You're somewhat of an expert about yourself. And therefore, this witness has all the information they need, and it is entirely rational for them to offer their opinion as to what they would do in a specific circumstance.
Mr. Lester, would you respond?
Yes, this clearly still falls under Rule 701 as this witness is a lay witness and the rule still applies.
Okay. You have no further elaboration except to repeat what you said before?
No, Your Honor, not at this time.
Okay.
Would you like a response on those grounds, Your Honor, or no?
Well, since Mr. Lester didn't really add anything, I'm not sure any further response is necessary. So you're asking, I'm going to sustain the objection. You're asking the question, how she would have done something in an event that apparently did not occur? How she would explain behavior that she says didn't occur, so that she cannot possibly have personally observed that situation and therefore can't now offer an opinion on the subject. You're free to argue that in closing argument. The witness is not free to give testimony on the subject. You may sustain the objection. You may proceed, ask questions. Another question, Mr. Christensen.
Yes, Your Honor, but before I proceed, can I clarify as to precedent? Would Your Honor sustain a speculative objection onto any hypothetical question given in court today? Or is it
Yes, the answer is pretty much with a lay witness.
Yes, Your Honor.
If with an expert witness, we have a different matter. But with a lay witness, speculation, I would sustain an objection to almost anything about what would have happened, because we're talking about situations that is not something the witness can have perceived as required by the rule.
Yes, Your Honor. So I want to make this clear. Ms. Barrow, did you touch the camera?
To be honest, I don't know. I don't have any memory of touching the camera or a ladder, but to be honest, I worked in that bank for over a year, and there's probably not a surface in that entire building that I haven't brushed up against or I don't know, cleaned at one time or another. It's part of my job. I do odd jobs.
Did you work at the bank when they renewed the security system?
Yes, I think that was in July. They have the security team come over and make sure everything's working okay. And yeah, I worked during that time.
Thank you, Ms. Barrow. Thank you, Your Honor. I have no further questions for this witness at this time.
Cross-examination.
Yes, Your Honor. One moment for the prosecution to set up. Your Honor, may I proceed?
You may.
Ms. Barrow, your hours at the bank are 8:30 a.m. to 6 p.m.
Yes.
And you came to work on the day in question.
The day in question, you mean?
Yes, the day of the robbery.
Yes.
Yes, of course. I apologize for not elaborating. And when you got to work, you came through the security entrance.
Yes.
And you turned on the lights.
Yes.
In fact, you logged on to the security system.
Yeah, usually Cassidy takes care of that, but I didn't.
But Sutton is the only one with access to the system.
Yes, I needed some extra access because she was going to be gone.
And you know nothing about cameras or computers?
No.
Now, Ms. Barrow, I'd like to talk about your mother. You moved in with your mother after they had a health scare in April of 2019.
Actually, my mom died when I was 5.
Yes, I apologize, your father.
Yeah, I moved in with my father.
And you moved in there to support him.
Yes, he had stomach cancer.
And you haven't yet moved back to your old place of residence since.
No, I mean, it works well. I have my own spot in the basement, and I have a good relationship with my dad, so I think I'm gonna stay there for maybe another month or 2.
Of course. And moving forward to the robbery, Ms. Barrow, you said that during the robbery you notified the police.
I pressed the silent alarm, yes.
But the police did not receive your alert.
I don't know. I mean, they came. I assumed they did.
Objection, Your Honor. Pursuant to Rule 602, the opposing attorney is asking my witness to speculate.
Mr. Lester?
Your Honor, I'm just asking if they are aware that the police did not receive their alert. I'm merely asking the awareness. Therefore, it is not speculation.
May I be heard?
Okay. I'm going to hold back. I'm not sure that's the way I heard the question.
So should I
So I'm
rephrase?
going to sustain the objection and just ask you to rephrase it to make clear that you're only asking about what the witness is aware of.
Yes. Thank you, Your Honor. May I continue?
You may.
Ms. Barrow, are you aware of how the police were notified of the robbery?
No, I'm not sure. I mean, I assumed it was from the pedal, but I'm not 100% sure.
Of course, and during the robbery, you would say that you complied with the robbers at all times.
I mean, yes, I was at gunpoint. I was afraid for my life. I kept thinking I was going to die. I was not in the mood for heroics or a stand for justice. I was afraid for my life.
Mm-hmm. And you even personally handed the money over to the robbers.
Yes, yeah, I filled it with cash. I gave it to them. Usually banks carry pretty good insurance, so I wasn't super worried about the money. I was just worried about my life.
Mm-hmm. Sealing the deal.
I'm sorry, what?
Sealing the deal of the robbery. You completed the robbery by handing the money to the robbers themselves.
The robbery was never completed. The police got there and it didn't go through. They're in jail.
Of course. And you don't know any of the robbers?
No.
Nor the getaway driver?
The getaway driver?
Are you aware of such a getaway driver?
I mean, I know that I've heard that there's someone that they didn't catch, and I saw the sketch, but I don't think I've ever seen anybody like that.
At least not personally before the robbery occurred.
Right. That the first time I had seen them was.
And are you aware, excuse me, of the camera in the Third National Bank?
Of course I'm aware of it.
And you are sure that you've never touched the camera in your entire time working at the bank?
Like I said, I'm pretty sure there's not a surface that I haven't touched while I'm at the bank, but I have no memory of touching the camera. And I definitely didn't get up on a ladder and move it.
But the camera is 12 feet off of the ground, Miss Barrow.
Yes.
And that's so tall, one might even need to use a ladder.
Even with an extra 4 feet to my height, I doubt I could reach it.
Yes. However, the bank does have a ladder in their possession.
Yes, there's one in the supply closet.
And you are sure that you've never touched this ladder?
Like I said, odd jobs are part of my job. I mean, I fix things, I clean things. I was there for the security check, so I mean, it's possible that I held the camera while it was being installed. I just don't remember anything. I'm sorry, I just don't remember.
That's fine. Thank you, Your Honor. No further cross-questioning at this time.
Redirect examination, if any.
Yes, Your Honor. May I proceed?
You may.
On cross-examination, you were asked about why you're still living in your parents' house. Has the reason changed for you living in your parents' house since the robbery?
Actually, it has. I mean, I told you that before the extra jobs were just to bring extra income in so that I could afford a trip to Paris. But this trial has taken everything. I don't have a job anymore. I don't have any source of income. I have these enormous legal fees to pay. It was like the medical bills disappeared. And then as soon as I was accused of this robbery, 1,000 more appeared. I can't afford to live on my own anymore. I couldn't if I wanted to. I'm absolutely broke. This has ruined me.
Thank you, Ms. Barrow. Thank you, Your Honor. I have no further questions for this witness at this time.
Any further cross-examination? Mr. Lester, any further? Mr. Lester, any further cross-examination?
No recross, Your Honor.
No, okay. Thank you, Ms. Barrow. Thank you for your testimony. You are excused. Okay, we have now reached the point of closing arguments. Are both sides ready to proceed with closing argument?
Your Honor, could we have a quick 5-minute recess to get ready?
A quick 5 minutes?
Yes, Your Honor.
I don't know that the 5 minutes is either quick or slow. Well, you could have a slow 5 minutes too.
Yes, Your Honor. A slow 5 minutes would be better.
Okay. Mr. Krisner, do you have any objection to that?
No, Your Honor.
Okay. I am concerned about moving the trial on, and then we have to take a break after closing arguments. So I'm going to cut it down a little bit. You can have a slow 4 minutes.
Thank you, Your Honor.
Let's get things done.
Yes, Your Honor.
Everybody be back on time, please.
Thank you, Your Honor.
The court will be in recess for 4 minutes. Timekeepers, please keep strict track of this and notify me as soon as the 4 minutes is up.
Yes, Your Honor.
Thank you.
Your Honor, the 4 minutes are now up.
Thank you. We'll now proceed with closing arguments. Or do we have both? We have the prosecution's closing argument, Mr. Cho.
Yes, Your Honor.
Okay, then let's get started.
May I proceed?
You may.
Members of the jury, this is a case about silent theft. Not every bank robber is waving a gun demanding money. Some robbers are just standing behind a teller desk, ready to hand cash to their co-conspirators. That was Parker Barrow on October 31st. The prosecution has more than enough evidence and will prove to you beyond a reasonable doubt that Parker Barrow is guilty of conspiracy for helping the robbers, robbery, and armed bank robbery. Let's talk about what you've heard. Parker Barrow was the lone employee at Third National Bank. Mr. Foley entered to make his regular cash deposit, and two masked women, Laurie Boosmail and Charlie Floyd, followed. Miss Floyd held a gun, and Miss Barrow calmly handed Miss Boosmail a bag of cash, and the police arrived. A getaway driver was waiting for them, but however, she was not found. But this robbery involves far more than two individuals entering the bank on a whim. As mentioned, there were two robbers, a getaway driver, and a bank employee. Jane Doe recruited everyone, gave them flip phones for communication, and assigned tasks. Charlie Floyd scoped out the bank a week in advance and brought a gun to the robbery. Laurie Boosman collected the cash from the teller, and the teller, Parker Barrow, tried to prevent the group from getting caught. Miss Barrow told Miss Doe that Mr. Foley deposited a large sum of cash every Tuesday. Miss Barrow adjusted the bank camera the night before the robbery. Miss Barrow failed to trip the silent alarm on the day of the robbery, preferring to calmly hand over the cash to her co-conspirators, a silent theft. Parker Barrow's parent has medical issues and needed money, but instead, Miss Barrow was saving money to go on a lavish trip to Paris, for which she did not have enough money. Isn't this motive enough? Opposing counsel tried to pin Miss Barrow's crimes on Cassidy's son merely because she worked around money. Is this not the same case for teller Miss Barrow? Using the same logic, wouldn't Miss Barrow actually be closer to money? Miss Sutton saw Parker Barrow sitting with Jane Doe. We leave it to you to infer what they were talking about that led Miss Doe to tell Charlie Floyd the inside woman for the robbery was the teller Barrow. She went as far to insinuate that she never touched the camera when there was clear evidence of fingerprints identified by Agent James. As for the defense so-called expert, Mr. Karpis said he does not know about the financial position of Miss Barrow's family. Ms. Karpis lied. According to line 109 of his sworn affidavit, he knows by fact that Mr. Hurst has medical issues. Why would he lie? Furthermore, Jesse Hurst, Miss Barrow's father, saw Miss Barrow with a flip phone, the same flip phone Miss Doe provided to each of the co-conspirators. This is strange. As Miss Hurst has said, Miss Barrow already had a different phone. In addition, Miss Barrow was also found on the phone multiple times, talking in a quiet voice like she was embarrassed. What would cause her to do so? We leave it to you to decide why such actions were taken. As heard during Miss Sutton's direct examination, the bank has a silent alarm. Set to call 911 when they're activated, and when it was checked the night before, the alarm worked perfectly. But Parker Barrow never triggered it. There's also a security camera in the Third National Bank. The night before, Miss Sutton checked that the camera was pointing in the correct direction, and it was pointing in the correct direction indeed. Miss Sutton left the bank around 5:31 p.m., leaving Parker Barrow alone in the bank. At 6:05 p.m., Parker Barrow moved the camera. He left the bank shortly after. While Sutton enjoyed his sandwich at Hans Hoagie's house. Charlie Floyd told you that she had a gun in the bank. According to a case, United States versus Dramiello, all of the robbery participants are guilty of armed bank robbery. Furthermore, a case called United States versus Shaw tells us Parker Barrow is guilty of any actions that her fellow robbers took. And the case of United States versus Bamier concluded that it is only an agreement to commit a crime is more than enough to prove a person guilty of conspiracy. This is a case about silent theft. Members of the jury, we ask you to find Parker Barrow guilty of the charges of conspiracy, bank robbery, and armed bank robbery. Thank you, Your Honor, and the members of the jury.
Thank you, Mr. Cho. May we hear the defense's closing argument?
Yes, Your Honor. May I proceed?
You may.
Something's missing. Agent James's eyes sweep the room one last time, giving it one last chance. After hours of combing through computer files, emails, and search history, hours of digging through cupboards, drawers, and closets, Agent James is still empty-handed. After getting a warrant, searching my client's house, car, computer, and cell phone, Agent James was unable to produce a single piece of evidence. Something's missing. And that's a problem for the prosecution because in today's trial, they were burdened to prove to you 3 counts beyond a reasonable doubt. They had to prove to you that my client conspired, committed bank robbery, and committed armed bank robbery. But members of the jury, if at the end of this trial you go back into deliberation and something's still missing from opposing counsel's case, you can't find my client guilty. So let's take a look at exactly what's missing in today's case. Finances, a motive. Opposing counsel wants you to believe that my client robbed a bank when she was in fine financial condition. Wants you to believe she robbed a bank when she had enough money and then some, was saving up for a trip to travel across the world. They weren't able to provide a motive. So why would my client risk everything and rob a bank? What else is missing? Any documentation of conspiracy. They couldn't show you a single text message, a single email, a single meeting. They couldn't show you anything that documents the conspiracy between the inside man and my client. Your Honor, they investigated my client's house, home, car, and cell phone and found nothing. Something's missing. Again, the 4th phone is missing. Opposing counsel told you that whoever possessed the 4th phone that matched the bank robbers conspired and was the inside man. But if you remember the direct examination of Parker Barrow, that's not their flip phone. It's not what they possessed, and opposing counsel couldn't prove it to you. They could not show you that my client owned the flip phone that matched the bank robbers. Something's missing. Opposing counsel's asking you to believe that my client robbed a bank for no reason. Robbed a bank and didn't leave a single trace of conspiracy anywhere. Robbed a bank, but happened to magically disappear the phone that she used to do it. But the jury, even worse than what the prosecution didn't bring to you today, is what they did bring. See, they told you that fingerprints on the camera sealed the deal. Your Honor, why in the world will my client, who's apparently so smart that she can hide any evidence of her committing the crime, not wear gloves? If she's so intelligent that she can leave not a single trace, why wouldn't she use a broomstick to push the camera up instead of leaving fingerprints? It just doesn't add up. Something's missing. They told you that she didn't sound the silent alarm. She must have been in on the robbery. Your Honor, you heard her. It's entirely possible that she missed the pedal for the silent alarm when she went to push it. It was under the desk. In fact, you're not supposed to check under the desk to see if you've pushed it because you're in the middle of being assaulted by robbers. They told you that that sealed the deal. But they can't tell you the other reason why that silent alarm couldn't have gone off. Their own witness, Cassidy's son. You heard her on cross-examination. She had access to the security footage. She knew she was a culprit. She knew she was one of the suspects being investigated. And she had 24 hours with that security footage all to herself. And they're asking you to believe she didn't touch that security footage. Asking you to believe that she didn't edit it. Something's missing. See, in the entirety of their case, Agent James didn't answer the question she should. She didn't even investigate the third parties. and they're still asking you to believe that my client sealed the deal. No. Your Honor, something is missing. And members of the jury, when you go back to deliberate that, you're going to have to remember that something's missing and find my client, Parker Barrow, not guilty. Thank you.
Do we have a rebuttal?
Yes, Your Honor. Before I begin, may I ask the timekeeper how much time I have left?
You may.
You have 33 seconds by my timer.
Okay.
Is there agreement from the defense that there's 32 seconds left?
Yes, Your Honor. It would appear that there are 32 seconds left.
Okay, then we'll proceed with 32 seconds. I hope you can do something with 32 seconds.
I'll try my best, Your Honor. This is a case about sign theft. This we know for certain. However, the defense tries to paint this robbery as a vocal and loud and incomplete. Yet you have all the evidence you need. The defense is not telling the truth, the whole truth. Your Honor, we ask you to find Parker Barrow guilty as charged of conspiracy, robbery, and armed bank robbery, as the prosecution has already proven beyond a reasonable doubt, or the sound thief will run free. Thank you, Your Honor.
Thank you. At this point, I believe both sides have completed their performances. May I get confirmation from each side that I need to hear? There's nothing further that I need to hear before we end the trial.
The defense has nothing further to present at this time, Your Honor.
Well, you're not going to get another time.
Yes, Your Honor. There is nothing further from the defense.
Prosecution?
Your Honor, there is nothing further from the prosecution either.
Fine, then this trial is concluded and we move into the process required to end this trial under as a mock trial. I'm going to, okay, at this point, we'll take a 5-minute recess, and I don't care whether it's a slow or long 5 minutes. And during that time, I ask team members to turn off their web cameras and their audio. The time is there for judges to use to help work through their ballots. And it's also there for teams to consult for the purposes of naming the STAR Awards, specifically Star Attorney and Star Witness Awards, that one team recognizing the other team. So given that situation, we will be in recess now for 5 minutes. I ask the timekeepers to keep track of the 5 minutes for me. Thank you.
Yes, Your Honor.
Minutes has expired. Do we have everybody back? Could I hear from a representative of each side tell us that everyone's back?
Yes, Your Honor. Everyone on the prosecution is back.
Defense?
Your Honor, everyone from the defense is back.
Okay. And I trust my judges are back. Scoring judges are back. Let us begin. It's appropriate. This was a fine round, and I think it was very competitive. And for all that effort that you put in, I think you earned a round of applause from this audience. Wherever we are, we applaud you. We now ask the two teams, we'll start with the prosecution, to name the star attorney and star witness on the other side. We need to hear from the prosecution first. Who do you believe on the defense side was the best attorney and best witness?
Yes, Your Honor. The prosecution would like to award the Star Attorney Award to Hunter Uresk, and the Star Witness Award for Simon Kisby for his role of Jesse Hurst.
Okay, thank you. Congratulations to those two. Defense, would you announce your Star Witness and Star Attorney Awards?
Yes, Your Honor, we would like to do that. So first, we would like to give our Star Witness Award to Alexandria Meshfodia. Sorry if I mispronounced that.
Kira?
Yeah. So
Thank
we
you.
thought you did amazing, awesome job. And to our Star Attorney, we decided to give that to Dane Lester.
Okay, thank you. Now, I ask the judges to all come back on camera. We have a little 5 minutes to give a critique. That's 5 minutes is 5 minutes for all of us, which is almost an impossible task for anybody associated with the law to limit themselves as we are asked to do. But anyway, I ask the judges to put themselves on camera, unmute yourselves so that we can see you. Okay. I see Judge Gray.
Yes, sir.
Okay, so why don't we start with you? Would you give us some comments?
All right.
I asked the team members to take yourselves off camera. Give us a little more space for the judges. I ask again, team members, would you take yourselves off camera? Okay, and our third judge is here, I hope. Well, we'll find out. Let's start with Judge Gray. Would you give us your comments?
Thank you, Your Honor. The kids did an outstanding job. I really enjoyed watching this particular online trial, and I just applaud every single student for persevering through all the challenges of this lovely online world. I applaud you also, Your Honor, for doing a great job with some really tough arguments. Both teams did a great job.
Judge Rogers, what would you have a few words to say to us?
Yes, sir. You guys did a great job. I was really impressed. I'm a former mock trial person myself. I was a part of the national online mock trial competition this spring. So I'm very familiar with the ins and outs of this competition, and I know the challenges that arise from it. But you all did a fantastic job. I'm really impressed. I do have just two things really to as critiques that I'll just give. It is important as for us. We're hearing this information for the first time. So it is important for you to speak clearly and slowly, just to make sure that we are following along what you're saying. A lot of you did that, but just as a general rule, that helps the jury members to understand what you're saying. And also, as a general rule, whenever the judge is talking, you are not supposed to be talking. There were several times I counted where there was a little bit talking over the judge. Just be respectful of the judge. When he talks, he's got the floor. But other than that, other than those two comments, I really felt the content was great and the performance was great as well.
Judge Ellis.
Good afternoon,
Your turn.
everyone. Thank you. I'm a criminal defense attorney in North Carolina, so I thoroughly enjoy, obviously, listening to the different defense theories. But in this case, I actually enjoyed both sides' theories. I feel like I'm a professional mock trial judge now because I feel like I do this 10 times a year. Now, role is a little different, harder to get a feel for how they're doing, but I thought both of these teams did a really good job of presenting themselves well on camera. They appeared to know what they were doing. Didn't seem like we were using a lot of notes, so that was really good to see, but I think overall both teams did an outstanding job.
Okay. I'll throw in a few comments also. Let me first say that I do think that both teams need to study the rules of evidence a little bit better. I would particularly note that Rule 404 is not a general license to put in evidence anything that was said out of court by a person who's unavailable. It's a much more specific rule, and you have to read it carefully. Having seen now several mock trials, I just want to comment on the visual representation. I think you should think about how far you're standing from the camera and how much of your face is visible. I think sometimes people were standing a little bit too far from the camera. As a general comment, suggestion that I would have, I think the top of your head should probably appear at the top of the close to the top of the of where what the camera can see. And that allows you to come a little bit closer to get a little bit larger impression of your face. At the same time, if you're very close, you can get too close. You can get so close that it feels like you're in our face, and you never want that situation. And then finally, I just observe that you want to think about the quality of your evidence and what's I would call the difference between hard evidence and soft evidence. Hard evidence in this case are things like the silent alarm, the fingerprints. Soft evidence is evidence that someone thought he was calmly handled the situation. He was anxious, or he was calm, or he spoke in a quiet voice, and we can infer something from that. All of those are relatively weak pieces of evidence to prove a case one way or the other. And so I think you want to always be alert to what are really hard pieces of evidence that the jury is likely to rely upon in coming to a verdict versus soft pieces of evidence, which maybe they help you, but they can't be the central part of your case. That's my comment. At this point, I ask all the team members to leave the room. I just want to check with the judges before we leave the room. So I trust that everyone else is getting out. As to the judges,